February.
Sorry, my lord, for late mentioning. Item number 36.
36.
36. And I will file an affidavit next week. So, Lordship may call this matter third.
My lord, I have an objection.
36, you have objection?
I have objection.
You have objection. Then when it reaches, we consider.
Yes, there is no stay, they are not allowing us to even work, my lord. But it's a case of regulation.
That I admit, but one thing, my lord, I will file one affidavit. You will,
let the matter
I just request that friend just to call this matter next week.
When there is opposition, we will, if there is objection, we will not grant. Yes, next. Item 2.
Here the improved order, your annex of 3 mallards at page 83. The present petitioner filed a OA application before the Central Administrative Tribunal, mallards, which has been rejected by the tribunal. It is annex of 3 mallards.
What was the case before the tribunal?
Tribunal says the document.
No, what was your prayer?
Prayer mallards, I am the eligible candidate for the post of attendance.
Project the money within which first order, last order, our.
You have not deposited the money.
Yes, yes, I have deposited.
Both.
My mallards.
Item 2. What was the prayer before the tribunal?
The annexure 1 is the OA application.
Appointment secured on the basis of false and forged document.
Minors.
That was
The
the
opposite party number, private opposite party is making forged documents minors. What happened? The sale authority made a requisition to the Bonegada Employment Exchange to sponsor the candidate with from those who are registered their name in Bonegada Employment Exchange. And Bonegada Employment Exchange sponsored the name of the present petitioner. And subsequently, taking fraud the documents, they have sponsored the name of the opposite party, which is those who are selected by the
what the tribunal has said, let us.
The tribunal said all the procedure are followed in
No fraud.
no product.
Then how can we interpret?
Without calling for the records from the Bonegada Employment Exchange, the tribunal decided this.
So take us to the reasoning of tribunal.
Because I made I got a information under the RTI Act in my original affidavit I filed, and that has not been taken into account.
You are one of the contenders in the.
Mallards. He belongs to Bonegada.
Only that.
The others, those who are appointed,
They have followed the earlier order. They have followed OA number 759 of 2015.
that is item number 4, Mallards, in the your lordships.
In today. This also is there.
It is there.
Let us take 759. Then we'll come to that. Come to 4. Who appears for the petition? You appear.
No, I am appearing for the Union of India OP1 minors.
Okay.
Actually, the contesting party is still at 3 minors.
4.
Same.
Pass over. Come to 3. Wait, we'll look into that and then we'll decide. Because if they have followed another judgment, let us see. Yeah. Item 3. This one.
Pursuant to the Lord's order dated 15th January 2026, the amount in question has already been deposited in the bank mirror.
You have deposited the money?
In shape of a demand draft mirror. I have also served the copy. My brother
Immediately deposited.
Deposited. What you are for the bank now?
I am for the
What are you going to do?
my lord.
Now he has deposited money.
Well,
Some more money is to be paid.
deposited in 11th.
He will pay along with the interest.
well, look, here about what has happened, essay is also pending.
by him. In a other writ petition in the last week, Lord Chief Justice,
Yeah.
that directed the DRT to consider all the
Now, what you want is money.
money.
Bank wants money or bank wants house?
No.
It wants money.
Hmm.
He is ready to give.
But he is 13 amount.
Huh.
There is some other amount of
You tell which is that amount?
Well,
We'll tell him to
Let's
deposit
call
that
this
also.
better tomorrow. I'll take the instructions over the outstanding expenses.
Because now, what is stayed now?
My lord,
The-
say that
Section 14.
Section 14
14 order.
application, which was passed by the London CJM, is not in accordance with the statute. My lord.
That we'll look into.
That is
You
my
bring money. What is that statute? You have taken money, you have to give back the money. That's all. With interest.
My lord,
Nothing beyond
whatever. Accordingly, I had also filed an application that petition has been disposed of within a direction to the dispose of the DRT within 8 weeks. Here, my lord, my intention to pay the dues because I have arranged a buyer pursuant to the sub rule 8 of rule 8 of the security interest rule by arranging private treaty because
Not private. It's only by, that is only by way of an exception.
Yes, sir. That application is pending before the DRT. My lord has also passed a disposal of this writ petition because I have arranged that money in that manner. So this is the position, my lord. My intention because property standing in the name of two brother, my lord. I am one of the brother. I want to.
What is the
Want to
due?
That instruction I need to take.
What for you are coming here? What for you are coming here? Huh? What is that bank case?
30
How much money is
13 to-
lent on which date? What is the amount due today? For that, this is not a case on the Bharti case.
The 13 amount was 3 crore 58 lakh.
That's what it should say.
That
3
was
crore 58, 84, 3
Yes,
to 1.
3 to 1. There's on 30th June 2020.
Yes, that
22.
22, yes.
Now that will be, what is the rate of interest?
Lord, after that, the rate of interest, 18% default interest.
8%.
How can you say?
It's a housing loan.
No, it's a commercial.
Commercial.
See, cash ready.
11
Now you have deposited how much?
Here, my lord, I have
89 lakh,
89
90
lakhs.
lakh.
My lord, 89 lakhs, 89 lakhs, 71,080 rupees. First installment, another installment to be paid on, I think, on 11th February 2026. Because
My lord, the first installment, am I permit to budget in the loan account?
My lord, the rule is saying my respectable submission. Recently, I have brought it to the Supreme Court.
If that is put there, at least the interest will not run.
My lord, my respect, but
Call it.
my lord, the interest bearing account, no lien interest bearing account, my cases will be disposed of. That is my respectable submission.
Then, well, you should show us the second installment you have to show.
Different, so interim order to be continued.
Order to continue. Subject to compliance of order conditions.
My lord,
Call on 12th February.
my lord, I have also filed an IA number 22.
What for?
I have heard that the amount in question deposited may kept in interest bearing loan lien account till the issues are disposed with the
Let us, next.
Deep oblige.
Item 5.
Who appears for the petitioner in 4?
I'm for the petitioner.
Yes. What was your case?
My case is the selected.
Fraud and fabrication.
Minus. The selected candidate who have registered their name in the employment exchange by virtue of a forged residential certificate and educational certificate also minus. But the sale authority with collusion with the employment exchange sponsored their name and they have selected minus. Though the petitioner is the residents of the Bonegard Employment Exchange and their names are also sponsored by the Employment Exchange.
When you knew that? When you knew that?
Yeah. So I made under RTI Act matters. I
When
sought the information.
When did you?
Completion of
When did
the
you make it?
after completion of the selection matters.
Then what can be done? When did you know all this?
But
Much before that.
I doubted that. Then that way I filed a RTI
You have to answer court's question.
matter.
If you avoid, then you know what we are going to do. You are in the temple.
Matters. I'm
When did you know that they have defrauded the employment exchange?
immediately when I know, immediately I made a application.
It is because the answer goes with.
Where have you stated about that? When you came to know about that?
In my rejoinder affidavit matters, which has not been.
Show that.
Here matters, what happened, I made a annexer 1 is the impugned matters.
They have
The
86 Supreme Court is found. 86 Supreme Court says, if you participate in the proceeding, selection process, without raising a little finger, then you cannot take up that contention. That judgment tribunal has followed.
matters.
Now we want to know. Therefore, that will be the trump card of your case.
Yes.
When you came to know that they have fabricated, forged certain documents, when did you come to know? Where have you stated about that?
In my rejoinder affidavit, I submitted all these things, matters.
So where is that? So you have said in OA only.
Wait.
You have not said that in OA.
In where I don't have seen my.
You have not said.
No,
Let us see how you have structured your case before the tribunal. Go to your OA.
Item number 4, the original application I have not been annexed, matters. I made
You have to annex all that, na?
annexed in item 2, I have annexed all these things, matters. But item number 4, inadvertently I have not.
Produce all those papers.
Matters.
Petitioner to produce all the papers that were part of the record before the CA. The next date of hearing, failing which petition runs risk of dismissal on that ground itself. Well, in the last week of February, along with 2. Yeah.
Obliged.
Item 5.
May I please intervention?
Yes.
In this case, the petitioner is the borrower and is approaching the Supreme Court for seeking equitable justice. The
How much money?
money he has availed 25 lakhs,
When?
20 lakhs loan availed in 2022, my lord. Thereafter, now at present, the outstanding due is 31 lakhs, my lord.
31 lakhs.
39 lakhs, 39,000. The petitioner's recorded land has been acquired by the National Highway Authority. He is entitled to receive 89 lakhs rupees compensation.
Award is passed now.
Award has been passed. The authority has intimated to the bank under Annexure 1 to the I number 1614 that the petitioner is entitled to get 86 lakhs. But
What is it?
Just now I received the copy of the request. I will take instruction.
Because his property is acquired and the LAO is saying so much money is due to him.
Definitely, money is inside with the.
Yeah. Why do you trouble them?
now they are going to sell the property 1 crore 61 lakhs.
Don't sell it.
I will take instruction.
You take instruction, but don't sell it.
Definitely.
Property is taken. Money is
Money is
that's
inside.
acquired.
They are going to.
I will take instruction.
Yes.
Yes, but
Heard learned counsel appearing for the petitioner borrower and learned senior panel counsel appearing for the bank first time.
I am to
Issue emergency. You appear for
Tahsildar competent authority.
learned ASC, Mr. Ray appears for respondent 3 first. Who is one?
1 2 is the bank.
Secretary. Why Union of India?
Union Bank of India.
Union Bank of India. You are right. You appear for the bank. See, sorry, so appear for OP1 bank, OP1 bank. Two is authorized officer.
Authorized of the bank.
One and two, both.
Both.
Brother, Mishra, you appear for one and two, both.
That's two.
They are bank authority only.
Both one and
We appear for heard learned counsel appearing for the parties. First, counsel for the petitioner points out that the property of his client has been acquired and by NHAI and an award is passed also. Semicolon. Further, the LAO or SLAO?
Conflict and Authority under Land Acquisition Act, CLA.
CLA has sent a letter as to certain sum of money being due under the award, and this letter is addressed to the bank itself. He expresses apprehension that before that money reaches his hand, the property furnished way of security may be alienated, and therefore the same should be halted. First off, there is force in this submission. First, we have also noted the objection, oral objection filed submitted by the panel counsel appearing for the bank. First off, the case is moved out for issuance of interim protection, and accordingly we pass the following order, interim order. The subject security property shall not be alienated by the respondents OP 1 and 2 till next date of hearing. Second, the petitioner shall not draw the award amount without leave of discourse. Correct. The competent authority, CLA.
Tahsildar Punjaga.
That is, he is a different Tahsildar, not R3, OP3.
OP3 is the Tahsildar the Punjaga who is designated as Kalla.
The CALA, Tahsildar, Jagat Singhpur.
Kujanga.
Sorry, so he is directed not to disperse the award amount to the petitioner without the leave of discourse.
Okay.
First. Next one. Call this matter up to 3 weeks. 3 weeks. First one. Registry to send a copy of this order to Kala Tahsildar so and so by speed post immediately. First one. The OP numbers 1 and 2 also hand a copy of this interim order to the said authority for information and needful action. First one. Violation of, next paragraph, violation of this order shall be viewed very serious. Okay.
Item 6.
May I please you?
Yes.
I may be excused. Impung order. Impung order dated 15/9
Releasing the property from attachment.
attachment.
On what ground?
On civil supply ground, because we have got a priority over there. This is a secure debt. Secure debt is bank debt.
Under the 2002 Surface Act.
Surface Act, my lord. And I have annexed this honorable court judgment.
Why Apex Court judgment is there?
Apex court judgment is there, but referring to judgment, our honorable High Court has been passed a judgment which has been annexed as a pays, my lord.
You take notice.
Sir, no, I have given copy to
Who
the
appears?
my lord.
I have for one. Others have to notice.
Others notice has to go.
Yes, ma'am.
Issue emergent notice. Ray on our request, ASC Ray on our request accepts notice for the
All are-
only one. Emergent notice to the rest, returnable within 2 weeks.
All are borrowers and others.
All borrowers, they have to come.
In this,
We do not know what they will say.
in this regard, they have not in the before the DM also when the
But
order.
you have made them parties.
As per my let me as per the direction of this honorable court, that the matter has been disposed of to approach the appropriate authorities. Appropriate authorities, in fact, is the DM Subarnapur. So I approached them as per the direction. So they have rejected that unless I will get the High Court order, I cannot do anything.
Let us, you take a notice to our rest of the people. Not.
It's declared
Matter lies in,
within 3 days.
read for conference. Matter lies in narrow compass, fall in the last week of February. Yes.
Obliged.
Item 7.
If the petitioner who is the borrower has taken a agricultural loan, my lord, from the OP number OP bank. Now, my lord, without serving the 13-2 notice, now without complying Rule 8 of the security interest rule, my lord, come to
What is the loan amount?
loan amount, my lord. Now, as per their bank statement, my lord, as per the possession notice, the outstanding, my lord, total 19,81,431. As on
About 20 lakhs. As on
4/7/25.
25. It will be roughly about 20.25, something like that. No?
And after that, I have also deposited 1.2.
1.2.
Annexure 7 series. After the possession notice.
You deposit 50% of the amount. 25% within 1 week, another 25% within next week. Now what has happened? Possession notice is given.
After possession notice, it was never served to the petitioner. Only
Sir, you are but borrower and you should go in search of the lender and pay the money.
Yes. Now on page 56 and the
You
auction
pay
notice.
50%. If you pay 50%, we will interfere. Otherwise,
My lord. Because after that, I have already paid 1.2.
50% of the amount due as on this day.
My lord.
Issue. You appeal for
The bank.
bank.
Bank of Baroda. I'm solving the copy, my lord.
Third, like as counsel appearing for the petitioner, find the learned panel counsel appearing for the OP numbers 1 and 2, bank and the authorized authority. First down. Learned counsel for the petitioner points out that without following section 13 and 14 procedure, coercive action is being taken for
E-auction.
and property is scheduled to be put in e-auction. When e-auction?
My lord, date is fixed to 11th February.
On 11th February.
Page
2026.
Next week.
Therefore, first, he also points out that his client has paid another sum of rupees 1 lakh.
1,20,000.
1,20,000
On 17/12/25 and 6/1/26.
On 17/12/25 and 6/1/2026 in the meanwhile, after the demand notice.
After
The demand notice. First, he also tells that he is trying to show bona fide by depositing 50% of the amount due as on this day. If some ease is granted. First, learned counsel appearing for the bank. Little opposes the first. Next, having heard the counsel appearing for the parties and perused the petition paper, we are of a considered view that the submission made on behalf of the borrower is prima facie worthy of consideration, and therefore reprieve needs to be granted as under. First, the e-auction is the scheduled e-auction is halted.
So far as the petitioner, because several.
So far as the petition property is concerned, subject to petitioner depositing with the OP bank 50% of the amount due in 2 equalized weekly installments. Failing which, not only interim order stands vacated, but petition itself runs the risk of dismissal on that ground.
Let the sale may be conducted but will not be confirmed without leave of the court.
No, the problem is, see, if once there is a judicial intervention, many people will not participate, and the auction value will go down. It is only 20 lakhs.
Yes.
And 1,20,000 has already paid. Therefore, we understand that our jurisdiction to interfere in matters.
No,
like
no, no,
this
that-
is
that-
limited. We understand that because a series of judgments.
That
But
I'm-
here is a bona fide, and he is going to pay 50%.
Madam, what I beg to submit, if he failed to pay, suppose.
Dismissal.
Dismiss it, automatically, again, we have to go for the. There is
Under banking law, every expenditure will be put on the borrower. Therefore, you have nothing to lose.
Item 8. Item 8.
In this case, petitioner has availed 3 loans, 1 housing loan and 2 top-up loan for construction of house. And the total outstanding dues as per the bank, by recalling all the 3 loans, 36 lakhs, 21,000. The overdue
When
amount,
it was?
Malak,
When?
I have noticed, as on 20/12/2024. 20
So
December.
that will be around 37 lakhs.
37 lakhs some odd as per the section 14 order.
Let them deposit 50%. At least that money you will get.
Malak, overdue amount, this is a term loan, is yet to be complete 31, 10 years, 20, 15 years term loan. Overdue amount only 5,32,000 Malak. I want to regularize that loan account.
You will pay that entire money.
Already, we have initiated section 14 and we have already.
It's all right.
Went-
But you want the money. You want your money back.
That is true.
That
That is-
term loan has been.
Or your manager wants that house to reside in.
That is
No.
money.
You want money. You will give that.
Instantly, I am giving 10 lakhs rupees. They may take instruction. If it will be regularized, then the possession can be restored. I am instantly I will deposit 10 lakhs.
You will pay.
More than
You
to
pay 15 lakhs.
15 lakhs.
Madam, may I place one, we have not filed our part. Let me take some instruction on that particular part.
We will request you to take accept notice. All right. Yes. Heard learned counsel appearing for the petitioner. And on our request, learned panel counsel Sri so and so appeared for OP numbers 1 and 2 lenders. First, next one. Learned counsel for the petitioner points out that it is a housing loan coupled with a term loan. Top-up loan. Top-up loan. Second, because of certain financial difficulty, the terms of loan agreements could not be kept, and therefore coercive action is being taken from the side of bank. First, he also tells that his client will pay 50% of the amount due. That will be 60.
20 lakhs. 18 lakhs.
18 lakhs. 50% of the amount due. If easy installments are allocated, so that issues raised in the matter can be deeply examined. First, there is force in this submission. Next paragraph. In the above circumstances, we what is the action now sought to be taken?
They have taken physical possession on 27th January.
Yeah.
Now they will go for auction.
We'll have the auction.
My lord,
Let him pay that money.
before the auction, they already have a right to redemption on their part. But
Redemption for full amount.
limited time may be granted.
That's one. In the above circumstances, we restrain the bank from taking any coercive action till next date of hearing, subject to petitioner depositing 50% of the amount due
That will be difficult to balance because the overdue.
in 2 equalized fortnightly installments, filling which same. Copy to be active. You have to pay 10% 2 weeks and 10% in another 2 weeks. All right.
25%.
No, now 25%. 24. You are right. Okay. Next.
Item 9.
Once after payment.
Yeah.
Item 9.
Item 9, my lord, kindly see the order dated 21/1/2016, last para.
1 lakh rupees cost.
Subject to it is not complied within it was complied before that.
Yes, my lord, they have complied and the appointment order.
Appointment order is issued to you.
Yes.
You have not brought the sweet to the court at all.
Yes, my lord. Poor man has got the benefits.
The operative portion of our order dated 21/1/2026, whereby petition was disposed of, reads as under. Next one. Learned AGA Mr. Behra very fairly submits that in view of compliance of this order by issuance of appointment letter, the cost of rupees 1 lakh be waived in terms of the judgment itself. First, there is force in this submission. Counsel for the petitioner respondent agrees before us that this order has been complied. Mandate has been complied by issuing the letter of appointment. Has he joined the?
No, my lord.
When will he join?
He will join after arranging some documents, my lord. There is a thought of.
In the above circumstances, Mr. Behra's submission is accepted and the liability to pay the cost is waived. Okay. Next.
Highly obliged, my lord. Highly obliged.
Item 10.
Item 10, your lordship, on behalf of Mr. Malik, may I read it?
Yeah.
Lordship,
Somebody should argue and argue well. That's all.
Lordship may peruse the last order, your lordship, 9/12/2025, your lordship.
9/12/25.
Yes, your lordship. It's a covered matter, your lordship. 3 writs has been disposed of by a common judgment, your lordship.
25 August 25.
Yes, your lordship. And 1 writ appeal has already been adjudicated by this Hon'Ble court, and that copy was served.
Yes.
That was in part of record, I think.
Writ appeal 226 of 2024. Do you have a copy? Hard copy?
Yes, sure.
Or you have hard time?
It is here. It is in record.
It's in record, your lordship. Last occasion, it was submitted to.
Right up.
Please.
Yes, it's here. That brother Mahapatra and brother sister Savitri.
Yes, your lordship.
The subject matter of this writ appeal, this appeal, is substantially similar to the one in writ appeal number 226 of 2024 between state and another versus Phanindra Kumar Mishra, heard and disposed of by a coordinate bench of this court, wide order dated 25/8/2025, dismissing the appeal. With observation at paragraph 7 as under. First, next paragraph. In view of wide order dated, so first one. Next, paragraph 7, 8, 9 of the said order are texted as under. Next paragraph. Learned counsel for the respondent submits.
Delay is there.
Depend on that.
Previous matter also. No, that was dismissed.
Submits that similar cases should be decided similarly, and therefore the terms coined in a cognate case need to be incorporated in this order as well. We agree. Next one. In the above circumstances, this appeal is disposed of in terms of the order in the cognate case above. Mutatis mutandis. In the separate order, I allowed separate. Leave it from this. Next.
Item 12 also same, your lordship.
Item
12.
Same.
Obliged.
But delay is how 69 days, na?
My lord.
Next.
Item 11.
Milords, item 11. Milords, similar matter is pending before the apex court for hearing 117(3), my lord.
17(3).
My lord. Similar.
No, what we say is, we will make the same order subject to what will happen there. That will happen to this case. All right. This is covered by which judgment?
My lord, so Bihari learned that this is the SLP number I
No,
have
not
given.
SLP. The judgment in SLP.
That is in
That SLP in that.
my lord, this is the number WPC
Right now.
number 15161 of 2019. No, my lords, OA. First is OA number
Not OA. Then
217.
it becomes WPC, na?
Man,
What is WPC number?
15161 of 2019.
19. Two options are available to us. We'll give that to you, whichever you want to.
My lords, what I pray, let it be just immediately after.
No, that will not.
Otherwise, your lordship may
What
pass
we will
that.
say is, subject matter of this is covered by the division, the coordinate bench decision in WPC 15161 of 99. We are told by Mr. Behra that matter is now pending in SLP before the apex court. Therefore, this appeal is disposed of in terms of coordinate bench order, subject to
Outcome of the
appeal, SLP. Right. The subject matter of this petition, go to 15161 of 2019. The subject matter of this petition is substantially similar to the one in WPC 15161 of
Two
2019.
cases. One is OA number 2171 of 2018.
Mr. Behra, both the cases have
My lords,
been-
challenged in writ petition
It has
that,
not been annexed.
my lords, para page 9, we have stated in our appeal memo.
No, in this petition,
My lord,
you have challenged, is it
that Kishan judge order is challenged before the apex court. My lords, OA was challenged in writ petition, then
because they were transferred? Okay.
Okay.
Before that. This intra-court appeal by the state seeks to call in question the order of a learned single judge in WPC
15161 of 2019.
15161 of 2019, disposed of wide order dated
23/8/2022.
22. But which is the judgment in put in a challenge before the apex court?
That judgment, my lords.
Which is 1516.
My lord.
In this, you are challenging order of the
My
single
lord.
judge. That order date I need to
My
need
lord.
to know.
I am giving one.
That is 2862.
My lords, that is
2223.
that is
Seeks to call in question a learned single judge's order dated 2/2/2023, entered in WPC number 2862 of 2023. First off, this WPC arose because of transfer of OA number.
my lords, it was not transferred. It was
Directly you have filed.
disposed of by tribunal.
A similar matter has already been 15161 by the division bench.
My lord.
The subject matter of this appeal is substantially similar to the one in WPC 15161 of 2019, heard and disposed of by a coordinate bench of this court wide order dated
23/8/2022.
23/8/2022. First up. Therefore, the coordinate bench views will be our views, comma, we being coordinate. First up, there is no reason to take a different view, and for that purpose to refer the matter to the larger bench. First up. Next paragraph. The above being said, we also note the pendency of SLP number.
SLP number.
Diary number it is.
No, my lord.
No, SLP number 006177 of 2024. So registered on 11/3/2024 on the file of Apex Court. Apex Court. First up. A pendency of challenge before the highest court of the country is ordinarily no ground for us to wait the decision on such a case indefinitely. First up. Next paragraph. Indefinitely. Come on. When there is no indication by the Apex Court that we should await the final outcome. First up. Next paragraph. In the above circumstances, this appeal is disposed of subject to outcome of the SLP number so and so. First up. If SLP is decided in favor of the state, comma, it is open to the state to seek revival of this appeal by moving an appropriate application in accordance with law. First up, in that connection, all contentions are kept open, ordered accordingly, and appeal is disposed of.
Well, it's delay of 353 days.
We will condone that. Brother, we will not condone that also, because we are not interfering. So all contentions, including the delay, all contentions, including the oneness relating to delay. No, not kept open.
Item 12 has been disposed of. Item 13.
Item 13. Last occasion also directed take instruction whether similar case have been continuing or not. Because agree by here.
Similar cases are there?
Yes, sir.
They are pending here.
By virtue of your lordship's order, lordship, now some candidates are continuing.
He's not on the similar footing, your lordship. He's not on the similar footing. No,
Agree by, because Sikha Sayaga, now by petition was continuing, while continuing as Sikha Sayaga, disengaged by virtue of this common order in the case of Rushikesh Bindani.
In other matters, we have made interim order.
Yes, lordship.
One matter, your lordship.
Referring to Olga Tellis.
Yes, your lordship. That matter, it was an interim order is there by virtue of which he is still continuing. But your lordship, here the petitioner, he has been for the last 22 years continuously in litigation, your lordship. He has taken representation. No, your lordship.
Not working.
No. Initially, he was appointed. He was disengaged. Again, he filed cases. Then on the basis of a representation and application in the year 2011, he was again re-engaged. Again, after the Bindani judgment, your lordship, and the order of this government, your lordship, again, they were disengaged in toto, all of them, your lordship. That was in 19, your lordship, 2019. 19. 19, yes, your lordship. 2017, the government had an order, your lordship, of disengagement, and section-wise they were disengaged, your lordship.
And you argue on merits only.
And in the year 2007, your lordship, this Prahlad Kaur, Patra, had filed a case and he had got an interim order. So by virtue of that interim order, he continued, your lordship. Then when that was disposed of in 2025, November 2025, after that he's been served with a disengagement notice, your lordship. Against that, he had come in the writ petition, your lordship, where your lordship has given him an interim protection.
So facts are a bit different.
Yes, he's been continuing continuously, your lordship.
The petitioner was initially engaged as successive Sikha while continuing as in the year 2000.
You deny what madam said till now.
Similar, no, total समस्त similar. All are similar.
You are disengaged in 2019.
Petitioner approach personal time. Your lordship kindly see annexure
No, you,
8.
the other person
Your lordship.
was in service.
Other-
Yours is in 2019.
2019 the petitioner is continuing.
Yeah.
Entry order was entry order was there to direct in the collector.
Sure.
He was initially disengaged in 2006,
Right.
Your Lordship.
Question.
Again, by way of
Was he-
2011.
One second.
Yes.
Was he disengaged in 2019 or not?
Yes, sir, 19.
Then we are not going. After 7 years, we can't.
Matter is pending with this court.
Correct.
Now acted by the order, your lordship, I am
We think that he was continuing.
but disengage, your lordship by virtue of now the again directed to consider already considered the matter by the rejecting the government. Your lordship
Issue emergency notice. Notice was issued already, no.
No, Your Lordship, on the first day.
The AGA Srimati Swain requested to accept notice for all OPs. First off. Learned counsel for the petitioner seeks interim protection on the ground of verity, pointing out that a single judge of this court is in WPC number 35117 of 2025 has already granted interim protection. First, learned AGA points out that the petitioner has not been in service since 2019 and therefore at this length of time no interim protection can be granted. First, we agree with this. Next paragraph. Therefore, we dispose of the application in IA number so and so without interference. First, main matter will be taken up along with WPC 1771 of 20, along with writ appeal number 1771 of 20. No.
35117.
Huh?
351.
No, Your Lordship, it is
Which is that?
along with writ petition number 35117 of 2025.
But that is before a single judge.
Single judge.
Yes, Your Lordship.
Okay.
before- That is, Your Lordship. Yes.
But this matter is the first week of March 2026. Yes. Next. Item
Your
14.
lordship, liberty will be given to the authority to consider that case. Is it interim?
No, we have already rejected. Yes.
Your lordship takes a date for hearing.
First week, second week of March. Yeah.
Notice issued on a limitation petition, my lord.
Huh?
He is not received on one CMPL filed, my lord. 8% dismissed, my lord. Due to the petitioner's advocate is expert on
Recall of order you are seeking.
my lord. Well,
When he expired,
2020,
when it was dismissed.
23, my lord.
Huh?
He expired in 2020 and it was
My lord.
dismissed in 2023.
To my lord. In meantime, my lord, is a respond number 2, my lord. Intimate to the department, my lord. Order is comply this order, my lord.
No, when writ petition was dismissed. Writ appeal was.
26th April 2023.
WPC was dismissed on.
26th April to 2023.
You want recall of that order
My lord.
on the ground of death of the counsel.
My lord.
Only one counsel or other counsel were on record?
My lord, other counsel is appeared, my lord. Read petition is filed. In meantime, he is expired, my lord, due to corona, my lord.
No. The coordinate bench wide order dated 26/4/2023 had dismissed this writ petition on the ground of non-prosecution.
Well,
First come. Now an application is filed supported by an affidavit seeking recall of that order on the ground that counsel on record appearing for the petitioner was dead and gone. First up. Death occurs in every house and that is recognized as a ground for recalling orders of the mind. First half. Next one. In the above circumstances, the applicant CMAPL having been favored, the order dated 3/5/2025 stands record, and as a consequence, WPC number so and so is restored to the board. Or post after 2 weeks. You give one book to the library. What is he? What is your client?
Electric department.
Huh?
Tata Power.
Tata Power. What is he doing then?
Tata Power is electric supply.
No, that's all right. Is he a sweeper or managing director of the Tata Power company?
STO man.
STO, sub-divisional officer.
You give one good book, Law of Writs Writ Jurisdiction under the Constitution by Justice B.L. Hansaria. This is subject to the, it's called application or petition? MP, so it's petitioner. Presenting writ jurisdiction under the Constitution by B.L. Hansaria, by Justice B.L. Hansaria, to the Advocates Library, within 3 weeks, failing which the petition runs, the writ petition runs risk of dismissal.
Item 15.
Follow up to 4 weeks.
15 and 16, your lordship, give me some time. I need some instruction.
Well, 15 and 16 is already covered by your lordship's judgment, which has been confirmed by Honorable Apex Court, your lordship.
That is, I just wanted to examine it.
You want to examine?
600.
Call it tomorrow.
Yes.
Let's call this matter tomorrow at the request of the jail. Yes.
Item 17.
Delay for 240 days only because the review was filed for against the said judgment, my lord, with the similarities. After dismissal of the review, before the appeal, these 2 appeals are arising out of 1 judgment. The delay of 240 days, my lord. Only ground is review, pendency of the review.
Was sent to make some one submission, lordship permit. 30 years before the lordship, 4 late applications, 2 review applications, all applications were allowed, would not be implemented, lordship's order as on date. Again, they say that after the lordship's order, contempt that filed, to avoid contempt, they give me 4 days appointment, again terminated, again writ application, again was allowed, again before lordship, again after 240 days delay. 240 days delay for present appeal, before the lordship from 96.
Yes, I will ask him.
That is, as your lordship, please, this is the only limited submission for lordship. Whatever the surplus will be disclosed of. Because I could not give justice to my client within these 30 years, though I have completed or fag end of my profession.
I filed the review within time.
Quickly come to paragraph 2. Read
of the petition.
A reproduced order. WPC 11663 of 2008.
Of the petition. Appeal.
No, appeal.
Oh, sorry, I was holding that limitations.
In order which rejected your applications for impleadment, arraignment. In that order, Brother Shashikant Mishra says that nobody is going to be affected by this order. Kindly come to para 2. To seek your arraignment, impleadment, you should be a likely aggrieved party. 58 Supreme Court.
No, here is the institution. is
Read
the
that.
Yes. So unnecessary details.
You read
The judgment.
para 2 of the order.
Yes,
You rejected
order dated
your application.
19/3/25. Order dated 19/3/25. The reviewer.
Review order.
No, which order?
You are right. 19/7/20.
724.
Oh, sorry.
Reproduced portion.
Yes, ma'am. Sorry.
In para 2.
Yes, ma'am.
52.
Yes.
In the concluding.
Madam, just. Yes, ma'am. In the concluding portion of the order of the director observing that without prejudice to the claim of the others, Sri Rameshwar Prasad Mishra should be reinstated as the lecturer in physics. Thus, no prejudice whatsoever would be caused to Sri Devasis Das or any other person. In view of the aforesaid discussion in WPC so-and-so disposed of, Rameshwar Prasad has filed WPC so-and-so to implement the order of director. In view of the disposed of so-and-so, this court finds that there is no impediment in implementing the order dated 1666 passed in the director. This court therefore dispose of the requisition directing the authorities to implement the order passed by the director as expeditiously as possible.
Yes.
This is the order.
Yeah.
What happened in this case?
This order you have put in challenge before us.
Before the Honorable Court. Yeah. My Lord, though I am not fully ready with the merit of the case, whatever little I have read, I am just submitting, keeping my right to explain details. If my Lord permit me, I
No question of it.
Yes.
You are arguing for admission. It's your appeal.
Yes, no, it is for limitation. That is why I was not ready.
Not ready.
Not ready. That was why I'm on the limitation I was there.
That is the request of Josh.
Yes, sir. Better. I'll do it.
Prepare well. Yeah.
Item 18.
18, my lord, it is a state appeal
Yes.
having the
Any similar matters you have decided?
Yes,
already?
decided and confirmed the
Confirmed by the apex court.
apex court, yes. This is one. Writ appeal, WPC writ appeal and SLP. Three decision and. So,
This this is a WPC.
Yeah, WPC thereafter writ appeal and SLP. Batch of cases. That what
Intra-court appeal seeks to lay a challenge to the order date. Seeks to lay a challenge to the order dated 10/2/2025 entered by a learned single judge of this court in WPC number 12522 of 2021, whereby relief in the following terminology has been accorded to the respondent. One respondent?
No.
To the respondent.
One respondent.
To the sole respondent.
Sole respondent.
Sole respondent.
Right, so that operating version of that order. That operating version is para 2021. You have to display this. Next para. Learned AGA, Mr. Mohanty, appearing for the appellant state and its officials. Although pressed into service a few contentions, we do not propose to examine the same in as much as the subject matter of this appeal is substantially similar to the one in writ appeal number 301 of 2023 between Additional Chief Secretary to Government of Odisha versus Khageshwara Jena, heard and disposed of a coordinate bench of this court, wide order dated 6/11/2023. Without interfering in the order of the learned single judge, even in the least. First of all. Further, at paragraphs 7 and 8 of the said order, the coordinate bench has observed as under. You already implemented in respect of rest of the people and you went in appeal in that. Take this. What is next paragraph? In the above circumstance, this appeal also has to meet the same fate. First, accordingly, appeal is dismissed. Within what period you are going to implement the order?
Well, at the operating party is at page 20. So fix the pay along with the increment notionally till the date of retirement for calculating it.
That order is there now. Within what period you are going to implement? Within 8 weeks from this day.
More time, because many matters are there individually, it has to be scrutined. For that I pray for.
Within 3 months, let them do. Outer limit of 3 months. Order of the impugned order of the learned single judge shall be implemented in letter and spirit within an outer limit of 3 months. Within which the guilty officials run the risk of contempt action.
Well, that delay be condoned. 180 days is there.
180 days is separate order.
Madam, similar matters are pending in this list. Item number 28.
Which is that?
Yes.
Item number 28 of this list.
Yes. 28.
27 also.
27,
28. 22, 2200 of 2024. And
May I pray? 20 days when allotted to some Mr. Panda. Let it come.
Let him come.
Series of matters are there. It will be scrutinized. It will be easier to
let Panda
make it convenient.
You're right. You can't make it. But single, all those orders are by, they are entrusted to Panda.
Yes, ma'am. The 28 is
Panda.
by that series of matters are there. It will be difficult.
If you duplicate that order in other one. Okay?
Item 19.
19, my lord, it is a state appeal.
Yes, sir. Covered by judgment? No.
my lord, that is your lordship. Covered by regularization matter.
Regularization matter.
We have completed. Initial date of appointment in the year 1982. And your lordship judgment is, Lord's single judgment is very clear because he has already been given retirement for that reason.
Jago and Shripad.
My lord, he has also record.
Jago and Shripad. But because only that ground, it is in the scheme, you know. At that point of time in 82.
But 40 years.
My lord.
That is not dispute.
He was in the scheme. Has he been removed?
No.
If
No,
he was
42 years.
No, ma'am.
You take it as a scheme, then allowed to continue.
You have to, if necessary, you have to create a post. No, you have seen that in Shripad, what the apex court said. You have to create supernumerary.
That is the end part of the story of the Shripad. No, there is Dharam Singh case, it has been decided. The latest one. But the last part, they have said that if at all it is not available.
My lord, without recording our concession, Lord, your lordship may kindly see your lordship's recent 2 to 3 days before. I'm sorry, 10 to 20.
In this matter?
Hi, the similar matter.
Similarly matter.
Your lordship relied Pradeep Panigrahi. If it is akin to Pradeep Panigrahi, then consider for grant of the similar benefits.
No, this is substantially covered by this judgment.
If your lordship permit, I may add only one.
What one word?
If your lordship
Spoil the
permit.
case.
No, that is what judgment my friend submitted for.
No, it covers your case.
My lord, then oblige, dear lord. For that reason, I say.
You should thank him for being so fair.
My lord, because
Client and
that was not given to me.
My brother has extensively argued, and what more I can add, my lord?
He has argued already. Right. The This intra-court appeal seeks to lay challenge to a learned single judges order dated 24/2/2025 entered in WPC number respondents serial number what is 29. In respondent WPC number 1008888 of 2023, whereby the following relief has been accorded. First, go to last paragraph. Verse 17. Next. Although learned AGA Mr. Mohanty pressed into service a host of contentions, they do not merit consideration again in view of our judgment dated 12/1/2026 entered in writ appeal number 975 of 2025 between Principal Secretary to Government versus Ashok Kumar Pattanayak and another. This word of white order dated 12/1/2026 against the appellants. Same appellants. What's next one. At the paragraph numbers 4.1 to 4.4 and in the operative portion of the judgment in writ appeal number 975 of 2025 entered in appeal number so and so, we have observed as next paragraph. That's all, no paragraph. What has been observed herein above in all fours, therefore, applies to case of the appellants, and therefore this appeal also being unworthy of merits is liable to meet the same fate as the cognate case. First, next, ordered accordingly, and writ appeal is dismissed. First, the impugned order of the learned single judge shall be implemented in letter and spirit within an outer limit of 8 weeks, and compliance report shall be filed with the Registrar General of this court in 2 weeks next following, telling which the erring officials run the risk of contempt.
Malad, as per the earlier, Malad said outer limit of 3.
I have said 8 weeks in the earlier. That also 3 weeks now, 8 weeks one, earlier, which he mentioned now. We cannot go on different yardsticks, same yardstick.
Delay may be condoned
163 days.
Delay. Yes.
Item 20.
Lordship, I am appearing on behalf of Dr. Mishra.
Yes.
Lord, in this, it is an identical case wherein notice was issued and copy was to serve on the other side. This is a...
My lord, that order I may be
issuing notice.
But your lordship was not inclined, were not inclined earlier to grant any indulgence in the matter, my lord.
Argue this matter.
Because yes.
Lordship, it is relating to the policy that was made by the temple administration.
We'll call this matter tomorrow along with this. So that both the matters.
Yes, yes. Let both the matters
Yes, yes.
together.
Grateful, Your Lord.
Call this appeal
If next week, my lord.
next week. Along with writ appeal number 1788 of 2025.
Item 21.
Item 21, it's a intra-court appeal, my lord. Some time is required. I have
a preliminary objection, my lords. I beg my lords to submit that. Lords, here my lords may see page, just a moment of my affidavit, at page 15 of my affidavit. Counter affidavit.
Generally, G will not ask time at all.
No, I have asked the department to come and convince.
Because of that, my contempt is becoming, contempt has become infructuous. The learned single is in what proceeding.
Request of.
The date may be fixed, my lords.
Yes, yes, right.
Much understood.
Item 22.
Please, Lordship. Lordship, this is the writ application, Lordship. This is the writ application.
Writ appeal or application?
Sorry, writ appeal.
Writ appeal.
Yes.
What is the difference between application, petition, appeal?
Appeal is the statutory right, Lordship.
Got it.
And application is it is made, that is not the statutory right, and it is made to this anybody to the.
Petition is where the authority has got abundant discretion, may grant, may not grant, but not like a Mughal. There's a good book on this. One judgment, the House of Lords, Lord Helspray's judgment. What is discretion? You have that judgment. Discretion means according to rules of reason and justice, not according to the whims and fancies of the judge. All right. They are petitions. Application again arises under a statute. Ordinarily, summary proceedings. Ordinarily. Unless the statute says, for example, Order 21, Rule 99, 101, 102, 103 of CPs, where obstructor supplication, that should be treated as a suit only.
97 onwards.
Order 21, 97 onwards of CPs. They are applications. This is appeal. You rightly said that. Yes.
The impugned order was passed on 10/9/2025, Lordship.
10/9/25.
Yes, Lordship. I have filed a application.
Any delays there?
Yes, Lordship.
How many days?
50 days, Lordship.
50?
Yes, Lordship.
52 days. Now, what is the matter on merits?
Lordship, is that I have purchased the land from the OSFC, Lordship. That is the State Finance Corporation Act under, but
Section 2930.
yes, 29(2). My case is coming under the Section 29(2), Lordship. May I place it?
Now, what the learned single judge has erred here?
Paragraph 19. 19, my lord. Now, page 19, paragraph 17, your lordship. Viewed in totality, the impugned actions of IDCO cannot be faulted. The petitioner's long-standing non-compliance with allotment conditions, unexplained delays, and misuse of property disentitle him to any relief in equity or law. IDCO was within its right to cancel the lease, allotment, and resume possession once it becomes clear that the petitioner was in fundamental breach and had failed to cure the same, despite opportunities. The conditions of allotment were clear-cut and were accepted by the petitioner with open eyes. He cannot now escape the consequences of his own fault. There being no procedural illegality or abuse of power demonstrated by IDCO in IDCO decision, this court finds no grounds in interference with the impugned order.
Lordship, but I have not purchased the land from the IDCO. I have purchased the land from the State Finance corporation, that's it. That is revealed in the annexure 1 of that writ petition.
You are not, there is another agency involved now.
Yes, initially the land was allotted to one lordship. That is the lease was granted
to Mr. G. Another agency is involved now. Yes. If she were to be the allottee under the IDCO, what you say is true. She has bought the land under 29(2).
Yes.
How section 29(2) reads? SFC Act.
Yes.
State Finance Corporation.
Section 29.
You want to suppose if you want bank upon too many sections, this suggestion will not do. Where you want to bank upon 1 or 2 sections, you should bring xerox of that. Judges will be very happy.
Yes, next time I will.
Yeah.
Section 29. Right of right. Section 29 is rights of financial corporation in case of default. That is 2. Subsection 2. Any transfer of property made by the financial corporation in exercise of its power under subsection 1 shall vest in the transferee all rights in or to the property transferred as if the transfer had been made by the owner of the property.
Then as if IDCO. Then what G says is correct. You cannot, this is almost on principle, nemo det quod non habet in Latin. Because you are deriving, section says that. Though agency is involved, subsection 2 of section 29 says, you will be standing in the shoes of the original allottee.
That means the subsection 2 says that I am the absolute owner of that property.
No.
May I please?
Reverse of that. Then read it again.
Any
transfer of property made by the financial corporation in excess of its powers under subsection 1 shall vest in the transferee, your client, all rights in or to the property transferred as if the transfer had been made by the owner of the property. Who is the owner? IDCO.
Lordship shall vest in the transferee all rights.
All rights as if.
All rights in or to the property transferred.
Correct.
As if the transfer had been made by the owner of the property.
Correct. But how this section is interpreted by various high courts in the country? As if, which is the judgment of the apex court. Yeah. Take out that decision of apex court. Apex court interpreted the expression as if. How courts have interpreted this subsection?
My lord. In paragraph 6, this question was raised by the petitioner. The petitioner's first concern contains page 14, my lord. Paragraph 6. The petitioner's first contention that the sale of the unit by OSFC under section 29(2) of the state finance. Yes. An option purchaser of a leasehold acquires only the interest of the original lease, etc., etc. I have explained it.
Because provision which says the auction buyer shall take the property free from all encumbrances. Such a provision is absent. You have traded that contention. Not a single judge has treated you.
Yes,
you may not be that satisfied. But there is a reason and logic in that.
Lordship, then possession was given by the OSFC. That I have not got the possession from the IDCO.
Whatever you are buying, again, Nemo dot quad non-habit will apply. You are buying the leasehold rights of the original grant.
Then Lordship, can't be some time. I will some judgment regard Lordship, as because again I want to read that subsection 2, Lordship. Any transfer of property made by the financial corporation in exercise of its power
Under 29.
under subsection 1, Lordship. Subsection 1 told that where any industrial concern which is under a liability to the financial corporation under an agreement makes any default in payment of any loan or advanced or any installment thereof, or in meeting its obligation in relation to any guarantee given by the corporation, or otherwise fails to comply with the terms of the agreement with the financial corporation, the financial corporation shall have the right to take over the management or possession or both the industrial concern as well the right to transfer by way of lease or sale and realize the property placed, mortgaged, hypothecated or assigned to the financial corporation. Originally the case land was...
That should be read along with next provision.
Yes, Lordship. Then any transfer of property made by the financial corporation in exercise of its power
Subsection.
under subsection 1, then Lordship, there is a comma and shall vest in the transfer all rights in.
All rights, as if is there. All rights in or to.
Then Lordship, or is there. Then Lordship, or to the property transferred is one part. Then Lordship, with every respect, that means shall vest in the transfer all right in had been made by the owner of the property.
Looking into this. Owner is who? IDCO.
But Lordship, in my case, I have not purchased that land. I have purchased the land.
Says,
that means
man is a woman. Parliament is saying it.
Then Lordship,
therefore, man is a woman.
Then Lordship, I have purchased the land from the OSFC. That means owner is the owner is the OSFC.
No. You have bought that property. Whose ownership? Lessee's ownership. There are 5 modes of transfer under the transfer of property. Sale, gift, exchange, absolute transfer. Lease and mortgage, limited transfer. In the case of these 3, the transfer is absolute one. Sale, mortgage and exchange. Section 5 of the Transfer of Property Act, read with 54, 66, 1097. All right. Now, the property belongs to that property was granted not in absolute. Lease was granted.
That is 99 years of lease, Lordship.
It is 999 years. Let us
that is mentioned in para 6. Only the interest of the original lease.
Interest of the original lease. Interest holder is also limited owner. Therefore, read section 5 of the Transfer of Property Act. New Transfer of Property Act. It defines what is a transfer. Look into that just.
In the following section, transfer of property defined. In the following sections, transfer of property means an act by which a living person conveys property
to another
in
living,
present or in future to one or more other living persons
along with himself
or to himself and one or more other living persons, and to transfer property is to perform such act.
Therefore, hereafter, section 54. Section 106, it appears, lease 105, something. That is also a transfer. Therefore, the word owner is used by the Parliament, keeping in view Section 5 of the Transfer of Property Act, read with 106. Though in so many words, learned single judge has not said, may not be, that is obvious also. In Orissa, in law schools, in which year Transfer of Property Act is taught? First year or second year?
That is Lordship, second year.
Second year. Mostly in all universities like that. No, yes, you have made all efforts. We'll appreciate.
Lordship, my humble summons. Kindly glance at the possession notice. That is Annexure 1.
Yeah.
We, the Odisha State Financial Corporation, a statutory body incorporated under SFC Act 1951, represented by the branch manager OSFC Baleswar branch, do hereby deliver the possession of the available assets of Messrs. Jagannath Food and Confectionery Private Limited at IDCO, serial number this, Industrial Estate Baleswar, Post Baleswar, District is to Sri Saroz Panda. This is the petitioner, aged 46 years, son of this, resident of this is more fully described in schedule below, height, sale letter bearing number this, dated ethic this, for a total sale consideration of 35 lakhs on outright purchase basis.
See, therefore I said nemo dat quod non habet. What is this selling? A lease creates interest in favor of the lessee. Correct? Lease is defined in Transfer of Property Act as transfer of right to possession and enjoyment, and the Act says it's an interest. Therefore, he is the owner of limited interest as against one. As against lessor, he is not the owner. Lessor is the owner. He has taken that property on lease. And that property, the Financial Corporation, OFC, has given it to you. It cannot convert that lease into a sale. It is as it is. Only power to transfer. Nothing, power not to enlarge Section 14 of the Hindu Succession Act, Marriage Act, the enlargement of a state. There is no such idea here.
Then, Lordship, kindly, my humble permission is kindly glance on Annexure 8. That is the cancellation order. On which ground they have cancelled my lease, Lordship?
Yeah.
May I place it, Lordship?
Yeah. They have said 1, 2, 3, 4.
Yes. Yes, Lordship.
They have not put the property to the use for which it has been allotted. They have breached conditions, etc.
In my SOFAs, I have written everything that I have got permission from the opposite party number 2. That is also revealed in the Annexure 2, Lordship. Annexure 3. Annexure 3, page number 13, Lordship. I have also got the issue of NOC in favor of the Hotel Raghunath. And I have submitted all these documents before the OP number 2. Without considering anything and without giving me any opportunity of hearing, they cancelled my lease, Lordship.
But that is not put in challenge before us.
Yes, Lordship.
You have put in challenge that
yes, Lordship. I have my prayer is also there, Lordship. Causing the order under Annexure 8.
Mr. G, this is not only 29-2. We are challenging that very cancellation itself.
But it's a writ appeal, my lord.
Correct.
Writ appeal, my lord. Intra-court writ appeal. The order of the Honorable Single Judge is under challenge.
Yes. Before the single judge, what was your prayer?
Prayer in writ appeal.
No, before the single judge.
Yes, Lordship. That is, therefore, it is prayed that Honorable Court may be pleased to admit the writ petition and after hearing be further pleased to allow the same through issuance of appropriate writ or writs by causing the order under Annexure 8.
That is 29-2.
No, Lordship. Causing the order Annexure
Cancellation also.
Cancellation order, Lordship.
Then requires cancellation. And that cancellation itself is put in. We were under impression because the single judge has considered only 29-2.
29-2.
He has not discussed about other prayer at all. That was essential. Because whatever grounds are available to the lessee, those grounds are available to the buyer under the lessee. Because of 29(2). Requires consideration. Heard, what's your name? You heard me so good.
Pragya Paravit.
Heard, learned counsel.
Pippi Mohanty.
So, who draws attention of the court to the order of cancellation of the lease and the order passed by the SFC under section 29(2) of the SFC Act 1951. 1951. First off, she stresses the language of subsection 2 of section 29 to tell us that the property in question is taken in absoluto by virtue of deeming. 7. Even otherwise, the cancellation of the lease itself could not have been done, which aspect has not been adverted to by the learned single bench. First, she argued very well and convinced us as to examination worthiness of this appeal. First, next paragraph. Issue emergent notice. Learned AG. You appear for whom? 1 and 2, IDCO.
Only IDCO, they have a separate penal, my lord.
Issue notice.
Only 2.
Permit me.
No.
Serve notice to the previous.
In addition to taking usual steps, appellant to serve copy of the appeal on any panel counsel representing the OPs, respondents. First of any interim order you have sought for?
Yes, Lordship. That is true.
Counsel draws attention of the court to IA number so and so, supported by an affidavit. And we had interim protection at the hands of the learned single judge.
Yes, Lordship.
First off, she submits that she had the protection of learned single judge when the petition was pending, and therefore, the worthy case having been made out for admission, application needs to be favored. We agree. First of all, in the above circumstances, impugned order of the learned single judge is hereby stayed till the next date of hearing. First, since this order is made ex parte, it is open to the other side to seek its variation if grounds do exist therefore. You have copy to be explained. You argued very well.
Yes.
Let him come back. Will come because return reverse in 2 minutes. In there. Just pass over and telephone that lawyer also. So come. Application is there.
I have to multiply that very well.
Pass.
Item 24.
You may call this lawyer, sir.
May I please, Your Lordship? Your Lordship, may I kindly have a glance to the last order, 22nd December 2025, Your Lordship.
With the coordinate bench.
My Lord. My Lord, the award was passed on the date 29 August 2023.
29/8.
My Lordship.
When were you, was it a case of dismissal or retrenchment?
Retrenchment, Your Lordship. Here we want to compromise the matter. You don't want to pursue the matter. Reason is that on the date of passing of the award by the London Industrial Tribunal, he was gainfully employed before different establishment. Now the award is for 2 lakh compensation and for reinstatement. We are ready and willing to pay 2 lakhs rupees towards full and final settlement. We don't want to proceed the matter. Since he was employed before a different establishment, question of reinstatement is not there, Your Lordship. And the second portion,
he should die during the when she was outside, she was gainfully employed.
My Lord.
Will come back. She will come back.
No, no, not because he has a better opportunity at a senior post.
Your thank is not agreeable. You are for the
management, Your Lordship.
Management.
Your Lordship.
Now what happened?
Last occasion, I have filed the memo on the date of passing of the award on basis of which the award was passed. Your Lordship has a glance to the award.
Page number?
Page number, Your Lordship, running page 37, the relevant portion.
37.
Your Lordship, 37, Your Lordship. I want to say on which basis the observation of the benefit has been granted. Issue number 4, Your Lordship, line number 4.
Notice was issued earlier.
Well,
Tribunal ordered 2 lakh.
My Lord.
Instead of back wages.
Instead of back wages, along with reinstatement, Your Lordship. On basis of the plea that he has not employed anywhere.
In lieu of back wages.
Correct.
However, though the award was passed on 29/8/2023, he was gainfully employed with effect from September 2022 before GM Iron and Steel Limited.
No, that's all. Therefore, they said pay 2 lakhs.
Well,
what would be the differential? Suppose if she were continued in your employment, how much money she would have got?
For the period in question, Your Lordship, 4 years, 14, 1,50,000, around 3 lakhs.
Around 3 lakhs. 3.5.
3 to 3.5.
If we pay that, it would be absolutely, in fact, doctrine of gainful employment, which O.P. Malhotra in his Industrial Disputes Act commentary discusses, that itself has undergone change now. Earlier, it was the employer who has to prove that she was not employed. Now, gradually, there is a shift after 1963 Supreme Court. Shift is that you have to show that because you know where you are employed or not. Number one, you means employed. 2, suppose if she is underemployed, she is entitled to 1 lakh rupees salary, but she is drawing 75 lakhs. For 25 lakhs deficit, you are liable to pay. That's how Punjab Haryana High Court, Delhi High Court, Justice Enlaw, Rajiv Sahar Enlaw has taken that view. Now they have said 2 lakh rupees to be paid. You are in challenge now.
No, Lordship, I am not challenging that portion.
Which portion you are challenging?
Now there has been engaged anywhere another place.
Right.
I am ready
to come back to you.
No, Lordship, will not.
No, you can't say that.
My Lord Senior might be in VC. Is from Bhubaneswar, Lordship, Mr. Das.
No, you can't say that. That's called reinstatement. Reinstatement means even if that employee is employed in abroad, in Microsoft, He may choose to come back to you. I knock at your door. I have order in my hand. Allow my entry into your premise. That is reinstatement. She is better employed is no ground. It is for her to decide whether I should continue in the better employment or I should continue here. That is the meaning of reinstatement.
And you are not challenging that also.
No, the person my longest senior is appearing for the opinion over 2 years in Mr. Das. He has taken time last occasion for taking instruction in the matter.
Now, all right. What instruction?
Regarding you will settle. There are 3 cases you will see. One case was settled payment of 1 lakh rupees. He has taken one signing by the form K. Then second is only she has claimed reinstatement, no back wages. He was reinstated in the sister concern. This is the third case. We will compromise the matter.
Compromise means what?
Regarding full and final amount 2 lakhs. So
what is compromise? You are giving less than what is ordered by the tribunal.
No, sir. We are paying that 2 lakhs was the full and final that was given.
Correct. Coupled with reinstate. If you say no reinstatement, then enhance that money.
Let my senior.
Even according to you, it is 3.5 lakhs.
6 lakhs.
Where is Mr. Das? Das? In the morning he was here, no?
No, sir.
No, he is not there.
Level of practices.
You go and bring him. Fetch Mr. Das.
He's what? Can you take him?
Yeah, you
I'll intimate him.
Possible.
Well.
That's the only point. We are not agreeable with your contention. That contention spurns the industrial jurisprudence, labor jurisprudence. Yes.
Item 25.
This matter of Ganasika regulation, the similar matter has been disclosed by the coordinate bench. I am also giving. So nothing to cause also survive to.
Which case?
I will clarify in the paragraph 1, 2.
Now that OTET, Honorable Supreme Court has said that every teacher, elementary teacher has to acquire the OTET. It is mandatory now.
That is a promotion mandatory. I also
one has to be once a primary school teacher, elementary school teacher. You may be right, but the Supreme Court has said in case of Maharashtra.
Supreme Court husband, I have annexed that in your Pramodaman case also.
No, it is not there.
It is that.
It
is that.
No, it is Maharashtra.
What are the facts of this case? This coordinate bench, Honorable Chief Justice's order.
My lord. Both the case in the one of the Jababazamaji case and the Pramoda Mahanti case. Both have already been regularized, my lord.
One cannot continue as an elementary teacher without OTET.
No, but that is considered. When we come to para 2 of the judgment,
my lord,
this is 26/4/2024. Is there change of law subsequent to this period?
Yes, my lord.
Which is that?
It was in the year 2025.
Is it?
Yes.
Then on this matter, you bring that judgment.
Yes, my.
Call next week at the request of the DG, Mr. Chief, who says that the apex court has declared OTET to be the requirement.
Minimum, yes.
For teachers' post.
Yes, for elementary teachers.
For elementary. Yeah. But that is not, that is subsequent to this judgment.
Yes.
Yes.
Item 26.
Increase a lot. Well, capping date.
This is the intra-court appeal, my lord. The Honorable Single Judge order in challenge, my lord. Let's see, before passing the date checks, my lord.
Yes.
Placing the date checks, my lord. Let's see, on the 17th October 2011, my lord, the respondent got admission enrolled at Gitanjali School of Nursing, Bhubaneswar,
for the course of GNM, my lord, which is a regular course, my lord.
GNM means?
My lord, that is a nursing course, my lord, 3-year nursing course, general nursing. My lord, on next date, my lord, 28 September 2012, my lord, the respondent was appointed temporarily as a multi-purpose health worker female through walk-in interview selection by the order of the CDMO Mayurbhanj on a contractual basis to work under the SC and ST Development Department, and she joined her duty on 13/10/2012, my lord. 2015, my lord, the petition was filed by some other persons, my lord, Alok Swai, before the collector and district magistrate Mayurbhanj, alleging therein that the respondent, while pursuing her regular GNM course in Bhubaneswar, is simultaneously working as a MPHW, my lord, that is multi-purpose health worker, female, at Khunta block, which is illegal, and further requested to take legal action against her, my lord.
She was working in another.
My lord, he is prosecuting her study in 2011, my lord. And
Study hours are how they are structured.
Well, structure is that he had to attend regular classes, so also the examination, my lord. But he engaged as a multi-purpose health worker in the schematic, my lord. In the schematic, my lord, service, he is selected, my lord, for the post of multi-purpose health worker in 2012, my lord. And some allegations are from different persons to the district collector, my lord, who is the administrative head of the concerned unit, my lord. In the next date, my lord, on the
GNM courses for how many years?
For 3 years.
3 years. 3 years.
So she got admitted in 2011.
11.
And joined?
And engaged in 2012, my lord, suppressing that fact, my lord. And continued, my lord, subsequently allegation made, and the ADM welfare officer, my lord, on 10/12/2020, 2015
Inquiry was
conducted, my lord.
And she was negligent in her duties.
Yes, my lord. For that reason, my lord, she was provided an opportunity of hearing, and subsequently the collector disengagement him from the services, my lord. He approached the then, my lord, the learned OIT, my lord, and subsequently the same original application has been transferred to this honorable court, and this honorable court and the honorable single judge, my lord.
When she was employed, she was prosecuting studies also, simultaneously.
My lord. And that's
my lord, my humble submission, sir, is before your lordship that I am prosecuting the study, but never attend the regular class, only attend the examination, for which I have never got the mark sheet and the certificate for that course.
Whether compulsory attendance is not there?
No, my lord.
Who is the principal of that college?
No inquiry has been made by the
whether attendance is compulsory or not. If we ask him, we will know. And his answer will be fate of your life. In nursing, under the nursing rules, attendance is a must.
My learned friend submitted the attendance register, my lordship. Kindly glance to the attendance register.
You have not attended at all?
Yes, my lord, I am attended.
You have attended?
Yes, my lordship. Kindly glance page number 51, my lordship. That is the attendance register of the year December 2014, my lordship. I am given entire chart, day-to-day affairs, my lordship. Page 51. So also in page.
No, how could you attend when you were in employment?
My lordship.
How could you participate in the classroom when you were?
I am not attended the regular class, my lordship. I never attended the regular class. Only I appear the exam, for which I have never got any certificate.
You have not got any certificate?
No, my lordship.
But
till now,
you are permitted to take examination.
Yes, my lord. Take examination for I appear the exam, but not got any certificate.
No, that is another.
He has not taken any permission to also appear the examination.
That is In the contract
No,
also.
is
my
it
lord.
that the authority has withheld your certificate
Not contract.
or you have not obtained it?
Withheld, my lord.
Withheld.
Withheld.
What ground?
That I have to take a instruction, proper instruction. Proper instruction, what ground they have but as per my instruction and as per the petition of the in OA, they have never obtained the certificate, never issued. And in the contract, there is also not there any permission is required for prosecuting in any courts. And as per the contract, continuous 15 days absent is for punishment. That is on the page.
Page 38 is the, my lord, 38 of the memo, my lord. The engagement order kind of conditions.
Para 8.1.
8.1. My lord, of my
8.1 of the reasoning. Impugned order.
Lordship.
Yes, read.
It is also found from the record that in absent statement submitted by the petitioner for the month of December 2013 and December 2014, the petitioner clearly indicated that she was on leave on the date of examination of so fixed, but it is found from Annexure E, all those relevant dates in absent statement of the month of December 2013 have been overwritten and the same does not match with the handwriting of the petitioner. It is also found along with the notice issued by the opposite partner 1 and 8/3/2016 copy of the inquiry report which is relied by the opposite partner 1 to pass the impugned order on 7/4/2016 was never provided to the petitioner.
Yes.
It is also
The report was not given to her. Then Ramzan Khan, which is that judgment, 91 Supreme Court.
91 Supreme Court.
But then it goes against you.
Yes.
Learned single judge have granted the relief.
This schematic service lordship kindly have gone through the engagement order. My lord, the conditions are indicated in page 38, my lord. But admittedly, he was prosecuting your story without any permission, my lord.
He says, I have never went to the school at all except for writing the exam.
How can a court, my lord, without
We do not know. We do not know. If you ask that question, how can we can't go to the school and ask what all happened in the school?
But in the condition, my lord, the objective of the scheme, my lord, lordship can it is to maintain the SC/ST students in the hostel facility, my lord.
Correct.
Health.
What she is saying is, I have never gone to school at all. There are such persons.
And the distance of the
go to class, but still they will fare well.
Lordship, distance from the place of his posting to the prosecuting institution, my lord, is more than 350 kilometers, my lord.
Correct. Therefore, she says, I never went to the school at all, the institution at all.
But certain period he was unauthorized absent. For that reason, if inquiry was conducted, he was provided the opportunity, my lord.
How long she was absent? Another
Lord, that period
where is the charge?
Lordship kindly see the inquiry report, my lord.
No, where is the charge?
My lord, he is not a regular employee, my lord.
No, therefore, charge need not be framed.
No, therefore he had provided the opportunity, my lord. Lordship kindly have placed.
Basing on what the inquiry was conducted?
But basing on the allegation from different persons, my lord. Allegations from different quarters. He had those facts were suppressed.
Oh, ABCD has
yes, my lord.
That he is not going.
Two persons alleged, my lord.
No, let all Cuttack market people say that. But the point is, what was the charge you had framed against her? Read that.
Lordship, Lordship, the inquiry report, my lord.
Inquiry report.
Lordship.
Page number?
Page number, my lord. 55, my lord.
Charge is respondent has prosecuted her studies in GNM. He has appeared in the examination. These are the two charges. What other charges you can take up now? She went for roaming, etc.
No, that's it.
Your charge itself is 1 and 2. You have said that
page 45, well. 35, the report.
You reproduced.
Lordship.
In your debt chart.
Lordship.
kindly come to 1, 2, 3, 4. Fourth item. 10/12/2000.
10/12, Additional District Welfare Officer Mayurbhanj conducted an inquiry on the allegation that respondent was negligent for a duty while prosecuting her JNM course and submitted inquiry report to DW Mayurbhanj. When it was revealed that the respondent was prosecuting her study at JNM while simultaneously working as ANM Khunta block without taking permission from appropriate authority. 2, my lord, she has appeared in the first year examination. First year examination, April 2013.
Third year.
Second year, December 2013. Third year, December 2014, my lord.
Correct.
And also appeared in the practical examination held on various dates.
Yes. On
Next,
which day? How many days she was absent? If you show
Lordship,
that she was regularly attending the classes, leaving the job, you can understand. That is not your case. She has appeared like this. On which date she appeared and how that has created any difficulty to you to justify dismissal itself.
Lordship, that is specific charges, Lordship.
Charges 1 and 2. Respondent prosecuted her study as JNM while simultaneously working as ANM.
Yes, my lord.
That is
also misconduct, my lord.
No, but that is not true.
Lord.
You have banked upon
Lordship,
the attendance register
of the
petitioner,
my lord,
writ petitioner, and all that shows she was absent.
Yes.
She was absent in the institution. She never attended the classes, although she wrote the examination. All right, examination there. Why did you not give the report of the inquiry?
Lord, I think that has provided to the collector's order, my lord.
Have you provided copy of the report? And you are kindly
to verify the report.
4 lines you did not read from para 8.1.
8.1, Lordship.
Last 4 lines. It is found that.
Lordship, given a pause to me. They improve.
It is also found that
17/3/2016, no further.
It is also found that the notice issued by the opposite party number 1 on 8/3/2016, copy of the inquiry report which was relied by the opposite party number 1 to pass the informed order on 7/4/2016 was never provided to the petitioner.
Never provided.
It is also founded that no further date was fixed for issuance of a notice pursuant to the order passed by this court on 11/12/2023. Learned AJ also failed to produce any notice showing fixation of the date.
When inquiry date is, no date is fixed, and if inquiry is adjourned sine die, then you have to send notice. Next date of hearing will be like this. Please come. Where is that notice?
That spend some time.
No, there is nothing. Because it's single judge recorded all that.
Page 47. 47. That is my explanation on which date I am absent, I am given to the opposite party.
What you are saying?
First year examination, April 2013, date 9/4/2013, 10/4/13, 15/4/13, 17/4/13 is the practical date. Well, in attendance, my lord, the next page 48 is my preference report, which is filed by the opposite party.
Preference report of your working in the
working, my lordship. On those date, I am appear before. Yes, my lordship. On those date, which I am appear before the examination, on that date I have written as leave, but it is overwritten as official one by the opposite party. That is also observed by the single judge in his judgment.
Now reinstatement with full back wages.
My lord, order is reinstatement.
No, full back wages will not be.
No, full back wages.
What is the order?
Reinstatement in service, the breakup period of service be regularized as due and admissible on such reinstatement of the petitioner. opposite party number 2 is direct to issue an order of registerment within a period of 2 weeks from the date of receipt of this order. Petitioner is direct to produce a copy of the order before the opposite.
So you are not entitled to back wages.
No, my lords, there is no order.
We'll make that clear that he will not be entitled to back wages.
For that, my lord, lordship can glad to the engagement order, the conditions imposed. Lordship, I am placing that. Lordship, the engagement is purely temporary, terminated at any time without assigning any reason thereof.
Not that ground. You assigned reason and terminated. Therefore, all these questions arose. Had you just discharged, nothing would have happened.
Being an ideal employer, my lord, we have provided him the opportunity.
It becomes punitive. Delhi Transport Corporation versus Workmen Delhi DTC, 91 Supreme Court. That clause you have not invoked it, Pablo. 91 Supreme, yeah, 91 DTC versus Workmen DTC.
The lordship may remitted the matter to the collector, my lord, to provide him the opportunity.
No, sir. No purpose will be served. Take note. This intra-court appeal by the state and its functionaries by the collector and other seeks to lay challenge to a learned single judge order dated 17/2024, whereby respondents WPC bracket C way number 430 of 2017 having been favored, direction has been issued for reinstatement for her in service. First of next paragraph. Learned AGA, ASC appearing for the appellants vehemently argues that the impugned order of the learned single judge is liable to be voided in as much as the principles of service jurisprudence have been violated. Semicolon. Secondly, non-furnishing of inquiry report per se cannot be a ground for setting aside the penalty order, punishment order in the absence of demonstrable prejudice caused thereby. First off, he also tells the court that the respondent being a temporary employee, is not entitled to the amount of protection which a regular permanent employee will be, semicolon. This aspect having not been adverted to by the learned single judge, there is error apparent on the face of the record, and therefore this court should interfere. First, next paragraph. Learned counsel representing the respondent vehemently opposes the appeal, making submission in justification of the impugned order and the reasons on which it has been constructed. First, he draws our attention to the contents of paragraph 8.2, where learned single judge has mentioned about non-service of the inquiry report, and therefore the reasoning of the learned single judge is consistent with the observation of the apex court in AR 1991. Muhammad Ramzan Khan versus Union of India. Union of India versus Muhammad Ramzan Khan. AR 91 AC swine so. And Karuna Karan versus ECIL 94 Supreme Court. 94 Supreme Court. Personal court. He also tells us that the attendance register was called for and that the same was manipulated by interpolation, which aspect has been discussed by the learned single judge at paragraph 8.2. First off, so contending 8.1. So contending he seeks dismissal of the appeal. Next, having heard learned counsel for the parties and having perused the appeal paper, this court declines indulgence in the matter, broadly agreeing with the reasoning of the learned single judge on which he has structured the impugned order. First off. We also add the following grounds, a bit elaborate here than that. Next, the inquiry in question is fraught with the infirmities in as much as the same was adjourned on 17/3/2016 sine die, and thereafter no date was given by sending notice of appearance of the respondent hereto. First off, thus, whatever proceedings have been held after the cutoff date of 17/3/2016, have to be treated as being null and void, the same having been held in absentia. First off. Secondly, an opportunity was given by the learned single judge while his interim order dated 11/12/2023 to produce the records to vouch their contention to the contrary. However, no such production was effective. First off, that would add to the advantage of the respondent. Next one. The vehement submission of learned counsel appearing for the respondent employee that his client had appeared in the examination, first year, second year, third year of the course is true. Since is true, gains acceptance in as much as he repeats before us that no diploma certificate has been, course certificate has been secured by his client. First of all, we assume this to be true because those who do not attend the classes but write the examinations may not be entitled to grant of certificate. First of all, if certificate is not granted, learned counsel for the respondent as rightly pointed out, court can assume that it is because of absence or shortage of attendance. Nothing contrary having been indicated from the side of the appellants. First, lastly, what the learned single judge has observed at paragraphs 8.2, 8.1 and 8.2 in the impugned order being relevant is reproduced. 8.1, 8.1. Next paragraph. In the above circumstances, this appeal being devoid of merits is liable to be dismissed, and accordingly it is, costs having been made easy in the circumstances. First of all, we make it clear that the respondent shall not be entitled to any back pay. Yes.
So he's on VC also. VC.
Item 23.
VC also Sushant Kumar Das.
23 also. Item 23. 23 also prefer tomorrow. Let's not take up tomorrow.
Tomorrow.
Well.
Sushant Kumar Das.
Come tomorrow.
Shall I go for item 24?
24.
Shall I?
Yes.
Item 24.
I have intimated my lord, my Lord Senior Mr. Das has stated that he is on VC.
Will?
He is on VC and today he will give the no instruction memo.
Is it? We'll have it next week then.
Can you take out day after tomorrow?
Day after tomorrow. Why
I want to close before your lordship.
Why do you think that I will die?
No. I am not personally involved. I have also taken instruction. It can be go up to 3 lakhs also.
Next. You 3.5 lakhs because you said 3.5.
3.5
differential.
3 will be for solve the purpose.
Counsel for the appellant management submits that he would confer with his client for enhancement of the paying ex gratia from 2 lakh to 3.5 lakh.
Towards the full and final settlement.
Huh?
Towards the full and final settlement.
Towards full and final settlement of the claim of the respondent workman.
Right.
Yes. Call them next week. Yes.
Item 27.
The identical to item number 18, my lord. That Judge Robert.
19. Identical order. 18. Serial number 18.
Yes.
18 or 19?
18.
18. Okay. Same one.
And 28 also same. But one thing, there are two types of cases. One is direction is given to consider in view of a Norsi Pradhan case, what your lordship is passing order. Another in case of a Kasidamana case. So that Kasidamana case also, I am subject your lordship will indicate that. Otherwise, they will think that only that direction is given in Norsi Pradhan case. No, Norsi same principle. To regularize the same and to give. But in some cases, it was directed to consider in view of a Kasidamana case, and some cases it was only Norsi Pradhan case. Your lordship is a director in Norsi Pradhan case. So
now lordship have passed in Pradeep Panigrahi. That is the latest.
Same order.
Same order, my lord.
But we have to add this sentence also.
Yes. But from the one. Norsu Pradhan. Norsu Pradhan has already been considered in that Pradeep Panigrahi.
No. Here he is saying that about Maharana.
That's.
The lordship I see. Similar matter also is confirmed by Honorable Appeals Court in Govardhan of the Hospital case. It was directed to consider in case of light of Kasidamana. And also Supreme Court judgment has been like Pradeep Panigrahi. That to be added, my friend.
No, that to be added.
In my case, 8550 through.
18 to be duplicated.
For 18, but only in respect to date of Odisha was considered mark.
So far, my in 8053 of 2023 case. 853, date of appeal 853. This will be substituted.
2021.
853 of 21.
No, no, 23.
23.
Yes, sir. But she got it in the list. After 5 cases.
This is an item number?
28.
28
series of matters.
Sub-item.
Sub-item?
Sub-item?
Yes.
Sub-item 2.
461 of 23.
No, 8053 of 2023.
Sub-item 5.
That is state of Odisha versus Sahadev Rao.
Sahadev Rao.
Yes.
850.
Rest of the orders are
28 first number is mine, my lord. That's a 2200 of 2024, wherein I am rendering appearance for the respondent. And at page 55, 24 to last one, 2424 up to 24, last one, page 4, page 55.
And what is that? We are duplicating serial number 18 order.
No.
Covered by judgment.
It says like judgment.
They have already passed that order, na?
Yes, that covers.
That covers everything.
Only in my case, WA number, writ appeal number 2430.
Our order at writ appeal 1222 of 2025, we have relied upon in disposing of serial number 18.
Right.
What we have said there applies to all these cases.
Correct.
Yes, my lord.
Correct, my lord. So far as my case is concerned, that was a case of retirement and pension. So far as my case is concerned, they have themselves regularized me, and thereafter regularization, they have filed the writ appeal. So I am covered by the writ appeal by your lordship. My lord, writ appeal number 1222. That is what. So for WA number 2430 will be covered by your lordships. The order dated in this 122225.
There is a group of appeals there. So after finalizing the draft, so that we shall not give any scope for unnecessary moving another application, etc. Right. Our court officer will request you to come to see that draft. Then we will finalize.
Yes, ma'am.
So that yes, for both of you. Yes.
Right.
Yes, ma'am.
Some get out matter.
So
I have that, please. I have got to.
You have it?
Yes. That's
My lord, our IA number.
For a delay.
Yes, that IA we have sought for modification or recall because we had already paid by then. I was not posted with the facts. 150 lakhs, incurring an total expenditure of 3 crore 30 lakhs. We have paid in each case where delay had occurred. We have complied with, but I could not submit that because I was not having that record.
In fact, we have ordered cost in all these.
Cost additional cost
of rupees?
Where 5,000.
5,000.
5,000.
You give up that cost money. Anyway, you are succeeding, na? We'll recall those.
My lord.
Yes.
That order was passed in this case.
This case is mixed up, my lord.
No.
Work charge employees and job contract.
That related to job contract, but inadvertently passed in this case. Therefore, I am seeking modification. In this case, first case.
That is for job.
This one.
Yes.
First case.
In tablet 2200.
Yes, my lord. IA number 3998. That is flag E. 3998.
That is 5,000 rupees only to each of the employees apart.
That is additional where the cost was not paid.
Apart
in fact,
from
we had
getting 150.
Yes, we had already paid by then, my lord.
150,000.
Yes.
You have paid that.
We in delay where delay had occurred.
Where Apex Court said.
Yes.
Okay.
Job contract. Yes.
Wherever that is levied, that he is saying that waive that recall that order.
Because that will.
Who opposes that?
No.
Will admit their appeal and keep it for 5 years.
Don't want cost also for
So no,
As employees, we simply want our regulation and penalty. That's all.
50% have already died.
Wherever they have retired. How many of you are retired now? You means your clients.
All my one person has retired. In my case.
Fortunately, there is no age of retirement for lawyers. And fortunately, there is such a retirement age for judges.
Our case is all retired.
All retired.
In my case,
My case.
I am retired. I am continuing.
You tell one by one which is retired, which is not retired.
Your application discloses or not?
In my petition, I have disclosed.
Is there any subsequent development where you have?
Yes, I have disclosed. In my counter affidavit to the condemnation,
You have disclosed.
I have disclosed.
In your case also?
Yes, my lord.
Then it's all right. I'll go to.
My lord, in my case, the appeal number 507/25.
This board of.
Draft or
Yeah, we'll send it. We'll send
Yes.
words, right? So you have to come along with the government lawyer. Ah. It is not waiting to be printed. Only recall of cost. Yes. Will come afternoon. Yeah. After eating lunch, we'll come back.
Matter where the auction held by the state financial corporation has been challenged. On the ground that the state has been held.
29, section 29.
29.
Yes.
29. Held on the teeth of the directions of this Honorable High Court. And the auction, there was no complete disclosure. I'm for the original loanee. Now, I had set up a Vanaspati ghee. I'm just, my lords, going through the facts. Wherever necessary, my lords, I'll refer to the documents. Now, this story starts somewhere in 88.
When did you borrow?
I borrowed in 1988.
88.
88.
How much?
Now, I borrowed 30 lakhs term loan and 2,75,000 as working capital. That's given in my lottery. Paragraph 2,25,000, 27,000.
Yes,
30 lakhs.
0.75.
0.27. I'm sorry. 0.27. 22 lakhs 27,500 rupees was the working capital, additional term loan, and term loan was 30 lakhs. That your lordship finds. Well, now I've in paragraph 3 of my brief. Now I'm arguing the second brief for reference.
What is the amount due as on today?
Well, they are saying,
even according to you, what they say, what you say.
Well,
they are saying calculation.
They are saying 6 crores 27.
And do you dispute that?
Well, I dispute that.
What, according to you, what is the amount?
My facts are a little different here. I have, my lords, 32 lakhs was borrowed. By the time of Caesar, the interest outstanding was only 6.46 lakhs. Now, your lordship has to view this in a broader context. My factory was set up with a my lords, investment of 5 crores 47 lakhs. So there, OSFC's portion was very small, minuscule portion was taken from OSFC. Now, bank and other borrowers were there, loan lenders were also there. Now, it was a running unit, which was, my lords, by virtue of some, at that point of time, there were political differences with the powers that be. And, my lords, it was 27, OSFC allowed itself Section 29 to be weaponized, and a running unit was seized, my lords, brought to the ground at the time of Caesar.
In which year it was seized?
96. Running unit was seized.
All right. After 8 years.
After 8 years, outstanding at the point of Caesar was only, my lords, 6-odd lakhs was the outstanding in interest, and the payments were more or less very regular. Now, they did not release. I paid 2 lakhs was the deposit and all that. They did not release the factory. Factory lay continuously in Caesar. My entire net worth was eroded. I was forced into BIFR. Now, BIFR, there was revival and all that, process went on. Then, I, with the promoters in their own initiative, approached the State Bank, who is the main borrower, and the State Bank was cleared. We cleared off the entire loans of the State Bank. No due certificates were obtained. And now, OSFC and EPCOL both hold pari passu charges. We have, on several occasions, at least for the 3 to 4 occasions, we have approached the OSFC, come to a fair settlement and OTS proposal. We will settle. Every time, my lords, OSFC puts the figure a little beyond me. It was one.
It arises by arithmetical process.
My lords, I'll tell you, lordships. And more importantly, the entire factory lay under the watch and ward of the OSFC. They have been charging us watch and ward under that heading also. So all that we asked for OSFC every time, and even more interesting, they had a proposal, OTS proposal in 2009, where the amount hardly came to 1 crore 94 lakhs. So I approached them. I said, now we have cleared the bank. Now you settle in the extant scheme. And 2007 OTS proposal, you settle in the extant scheme and take my money and settle. Now they lay my application lay over for a year. They did not decide. Then after 1 year, suddenly they reject my proposal, telling me that since you are in BIFR, your unit is in BIFR, we will not settle.
Because Vallabha Glass versus so and so said like that. Supreme Court judgment.
Vallabh Das.
Yes, Vallabh Glass.
Vallabh Glass.
Yeah.
Glass,
Said like
Vallabh Glass. My lords. That is, here it was an OTS proposal. I was willing to settle from, there was no bar for them to take their own money. I was giving them under their official scheme. The arbitrariness was not there.
Can anybody take out that Vallabha Glass versus
I will, no. Vallabh Glass.
Though subsequently it is toned down. During that period, holding the field.
Well, the arbitrariness was not there. Arbitrariness subsequently what they did.
Class works versus Union of India.
Well,
I've 971.
That judgment I've gone to that. That, well, after 1 year, they turned down an application only on that plea. Exactly 1 or 2 months thereafter, they gave me another offer. However, you are free to settle under 2011 scheme. Now, 2011 scheme contained the very same clause. If you are refusing me in 2009 and you turn it down in 2011, saying that clause 3, subclause 2 stands as a bar, on the same clause being there in the second OTS, how are you offering me that? So I approached.
After all, it is all privilege. You are a borrower.
My lords,
debtor should pay back the debt.
My lords, there's no denying on that. There's no denying. I'm still ready to pay back the debt. There's no denying on that. Now, my lords, I approached this honorable court. And then, my lords, I gave an offer. Said, all right, because at the time, the same clause was prevailing. So if you are giving me the same thing now, why not under the 2007 scheme where the amount would have been considerably less. Now, why are you arbitrarily enhancing the amount? Now, the matter lay pending before this court. Court finally disposes of in 2022, directing me that you approach them in the OTS. The OCFC's counsel was also there. And the court permits me, this court permits me that you raise all the contentions. All the contentions will be raised comprehensively, and they are to take care of all the contentions, take note of all the contentions, and then decide your application. So, my lords, before I gave them that offer under the OTS, I also told them that let's conduct a joint inquiry now, joint verification of the assets, because you have seized my assets also, and they are under your watch and ward for all this time. So, whatever is there, as per the seizure list, whatever was there, and let's have a joint verification today. Whatever is existing as on date. Now whatever has been lost, that obviously, my lord, cannot go on my head. So you deduct that loss and then do the OTS. And then, my lords, we'll settle. Whatever is the amount, we'll settle in that. Now, that proposal was also turned down. Then again, my lords, we deposited 20 lakhs. Another, my lords, deposit of 20 lakhs was made. That is also there. They accepted that 20 lakhs was there in that account. And we gave a fresh offer that, all right, you do the verification, you do the, tell us what assets, what valuation you have put on the figure you have fixed on the assets. We will look into it, minus we will settle on that amount, minus the, whatever has been the depreciation of that, the asset that is there. That itself was, more than 3.5 crores. And for hardly 6-odd lakhs and 30 odd lakhs, when the payment as on date, we have already paid back more than 170%. That is, more than 70 lakhs have been paid off. So therefore, when the matter came up, and then they arbitrarily rejected that and went in for an auction. Then when it came up, when I came before this court said, all right, you can go ahead with the auction, but don't finalize the sale without leave of this court. While doing so, the court also, learned counsel for the OSFC was there. The court also, my lords, told them that you come with a fair offer. You can't enhance a 30 odd lakhs to 6.5 crores and for no fault turn. These people have been clearing the debts. It's not that they're running away. It's an established, it was a running unit you seized and ran it down to the ground. So you come with a fair offer of OTS and we'll direct you to settle. So that is where the situation lay. In the meantime, they had an auction. The auction was knocked down in favor of the fresh purchaser. Court asked us to implead the fresh purchaser. The OSFC did not disclose that the auction was held under the orders, agencies of the court. So the highest bidder, my lords, wants for the money back. And it is at that position. Now, my submission before your lordship is this one. I also implemented the EP call. I have, my lords, a twofold proposal, my lords, to prayer before your lordship, my lords. One is, my lords, the OTS, I am ready and willing for the OTS, my lords. My readiness is already there. My lords, I have deposited the money as per our offer. 20 lakhs is already there in the bank with that, with the receipts and all that we have given.
How learned single judge viewed all your arguments? Just take us.
No, division bench.
Yeah.
I'll tell your lordships what.
No, what is that? Why are you before us?
I am before your lordship, my lord, with the simple prayer that you allow me to do an OTS with them, one, and have a joint verification, whatever is the depreciation that we will deduct, and we go ahead. I'll settle both OSFC and the, my lord's EP call in my own volition, and I want to be relieved of my debt burden. Why unless...
Repay the money, everything will be relieved.
Why unnecessarily go in for an auction, go in for my entire property? Property is worth a huge amount.
Maybe. If you pay this question will not arise. When debtor is not scrupulous, when he wants to retain others' money and sit squat on that, all these arguments will arise. You honestly go and tell the lender, Mister, you have lent me money. I am paying it with you. All questions will not arise at all.
I'll take your lordships. To this order. Kindly page 56. This was the order. Order number 12, 5/4/2022. Learned counsel for the petitioner states. No, this was another one. Not that one. That's another order. I'm sorry. This order is at page.
What is the amount due as on today?
Lord, that is 6 crore 46 lakhs. Annexure 16, madam. Impugned order is Annexure 16. They have challenged Annexure 16.
Let us see the order.
Annexure 16 is the impugned order, page 88.
Go to 16. 15 or 16? An exact.
16. Page 88. Page 88.
Counter affidavit.
No, it's in the REIT.
In the REIT, my lord.
In the REIT.
In the REIT. In the REIT, my lord, 17064, my lord. WPC 17064.
Your lordship may see the principal is 27 lakhs, 87,000. Interest is 6.
Correct. Very Dam Dupat is not applicable to them. The doctrine of Dam Dupat is not applicable to them.
And then your lordship will see the amount is 6 crores 40. At the time of Caesar, it was only 6 lakhs, 6 lakhs 17,000.
That was 30 years.
Yes, 30 years.
30 years. It's a compound interest under your rules.
So Lordship may kindly come to the order number 12 dated.
No, we are telling one thing.
Balance.
We are not bankers.
Yes. No, that's
now we are
quite right, Balance.
co-obligates. Well, we examine things.
Balance.
Prima facie.
Quite right. Quite right.
Matriculate level of mathematics.
Quite right.
You are saying that amount is huge. Where is your memo of calculation? Give us. How you are, on what basis you say that amount is very huge? It becomes very huge.
I'll tell you, Lordship. Lordship may kindly bear with me. I'll tell you, Lordships. Lordship may come to page 56. Learned Counsel for the petitioner, this is the order 12. Learned Counsel of for the petitioner states that the petitioner is prepared to approach the board for OSFC for settling the dues under the extant one-time settlement scheme. Learned Counsel for the OSFC states that OSFC will consider such application if made in a time-bound manner in terms of the prevailing scheme.
Prevailing scheme.
If such an application is made not later than 2nd May 2022, in which the petitioner is permitted to raise all contentions in a comprehensive manner, listing out all relevant factors, it will be considered in terms of the extant scheme, and the decision of OSFC be communicated to the petitioner not later than 4th July 2022.
Correct.
Now, my lords,
so your argument, in the mid of your argument, you say,
my lords,
my case should have been considered under 2008 or 9 scheme.
Well, that I have put all
that is not available to you because of disorder.
No, this actually encompasses all that. Extant scheme, there are 2 schemes. I came to this court. When I approached this court, the extant scheme that time, when I approached the court was
what is meant by how Apex Court interpreted the word extant?
The prevalent scheme. Prevalent.
That's all. Not
even
logic. Then what?
Let us I focus 2011 scheme. Your Lordship may
you kindly articulate what are the grounds of challenge.
Page 7, Annexure 7, page 58.
No, tell us the ground on which then we will examine all that.
This is the scheme.
This is not liable to pay.
This is
that's way you articulate your point.
My articulation would be this,
Number 1.
I would.
She will write down. What sir says. Yes, sir. Articulate.
I'm sorry,
No, otherwise we cannot go on like this. You are a borrower. What are your rights? First, your duty is to repay the loan.
Lordship may kindly come to my proposal, my lord. The proposal that I
will come. What is your articulation of the grounds? What are your articulations?
My lord,
you tell those grounds, then we'll examine in the light of the record. We'll examine your contentions. You tell what are the infirmities in the impugned order. You are in appeal.
Right.
Still, how are you going to argue the appeal? You have to tell.
No, I'm not in appeal. I'm in appeal.
Infirmity.
No, I'm not in appeal. I'm in a read. Directly.
You are in challenging the order. Appeal means not jurisdiction. Review. Still, you are worse. If you say you are not in appeal, it will be worse. Because we cannot sit in appeal over the decision of the lender. Lender is a statutory body. How can we?
Now, my case would revolve around paragraph 2. The Learned Counsel for the OSFC states that the OSFC will consider such application if made in a time-bound manner in terms of the prevalent scheme. Now, the prevalent scheme would be the 2011 scheme.
We do not know.
Hearing you. The OSFC will decide. If such an application is made not later than 2nd May 2022, in which the petitioner is permitted to raise all contentions in a comprehensive manner, listing out all the relevant factors, it will be considered in terms of the extant scheme, and the decision of the OSFC be communicated to the petitioner not later than 4th of July 2022.
You are agreed with the order of the
manners. Then I gave this scheme. Then I gave the offer at page 58, that is Annexure 7, where I raised all the contentions in a comprehensive manner.
What are your contentions?
Annexure 7.
Put the 7.
1. At the outset, an outline of facts of the matter is given for better.
7 is a newspaper.
No. Annexure in page 58. Second read. Read petition number 17064 of 2020.
Why 2 read petitions?
The first one was I came before this court. that you, with the same proposal, that you allow me to approach the OSFC, and the OSFC will, your lordships had already allowed me to approach the OSFC. OSFC did not consider. And that writ petition with the same offer, that writ petition was noticed both on the IA, on the
What is the prayer in that writ?
No, same.
In that petition, he has filed an application for reduction of OTS amount. That was rejected. Against that, he has filed 9492.
That order is dated?
Order is dated.
That is
petition of the borrower. In terms of an order before the Finch had made an application with all grounds, which the SFC was to consider in terms of different OTS claims. First, is application for reducing the amount.
Yes, madam.
Reducing which amount?
Reduction of the OTS amount.
Only by the
his request. Who had reduced the? He had requested for it.
Yeah, no, that is there, well, in
his own money.
On an annexed.
Lordship, the prayer is this
for the OTS. OTS is an offer.
Prayer is this.
He has offered OTS.
You have to either accept, not take.
Yes.
Is it?
Yeah, Lordship, talk to my counter. I have annexed the document, madam.
No.
Yes, he has offered an OTS. This OTS was accepted.
What was the amount?
Amount was, my lord, 1 crore 94 lakhs. One crore 94 lakhs 64,000. 1 crore 94 lakhs 64,000.
1 crore 94 lakhs 64,000. That is dated.
That is dated.
That is dated, manner 24/1/2024.
24/1/24.
20, yes.
No.
That is the impugned annexure, annexure 15. Annexure 15 is dated
24/8/2013.
24/8/2013.
No. Annexure 15 is not 24/8.
In that, he had made an application for reducing this amount.
No. Thereafter.
Thereafter.
Yes.
Annexure 15 is 24/1/2024. Annexure 15, page 86 of the first rate.
My annexure 1 to the counter, the lordship will find at page 20, my lord.
Yes.
Last 20 is my counter.
So let us see the impugned orders for a moment.
Yes.
Because you have to make out a prima facie infirmity in that. And we are not in appeal. It's a judicial review. Therefore, Hari Vishnu Kaman. You cannot go beyond Hari Vishnu Kaman. Then you have to show that.
Page 88 is the impugned order.
86. 86 of the first
rate. Second rate.
Second rate.
Two orders you have challenged. One is Annexure 15. Correct. Annexure 15 is dated.
Second rate is
24/1.
January 24.
Yes.
Second rate is.
This is in the first rate petition.
This is in the first rate petition.
WPC.
24/1/2024 is first rate petition.
WPC.
WPC, my lord.
No. 496 of 24.
Yes, ma'am. 4296 of 2024.
Another is Annexure.
Annexure 16.
Dated.
Dated 17/6/2025.
Annexure 16 is the demand.
170.
That is in 170.
17064/2025.
17064
by 2025. That was the impugned order in second rate application.
Let us see Annexure 15 now. What are the apparent defects in that?
Appeal for reduction. Page 86. 87, I'm sorry, 87. This is reference to our last letter dated.
Well, this your 194.64.
Yes. Manage.
That was pursuant to your
delayed
your letter dated 6/4/23.
Manage. Yes. Within a period of 3 months from the date of communication.
Your letter is 28/12/23.
Their
Let
letter
us
is
see 28/12/23.
Manage.
Show that.
28/12/2023.
What colleagues? In the first answer, page 82.
Page 82, annexure 13. Page 82, annexure 13. Mallards.
What you had said, what was your offer? 194.64. Kindly come to Roman 9. That OSFC came out with another settlement scheme, so it's also a letter based on company for settlement of all its outstanding dues at rupees 194.64 lakh. Calculated as per the terms of the scheme itself, inclusive of initial deposit. The approval letter thereafter being revoked. That the company wishes to raise the following contentions.
Mallards.
You raised these kind. What is first contention?
Paragraph 3, your lordship may kindly come to paragraph 3. That the orders passed by the Honorable High Court permitted the company to make an application for OTS. That is it.
Kindly come to paragraph 2.
Paragraph 2.
The company wishes to raise the following contention. No,
yes.
Internal page 3.
Internal page 3.
Page 2. Page 2.
The company wishes to raise the following contentions. The company has been with all earnestness trying to settle the outstanding OSFC, outstanding of OSFC in this effort several times.
Second.
As against a loan of 32,27,500 availed from OSFC, an amount of rupees 54,81,881 had already been repaid by the company. The manufacturing unit of the company has been established at considerable cost. The unit was seized for delay, lapse in making payment of interest.
You delay and lapse on your own part.
In making payment amount of interest of rupees 6,31,000, seizure of its only manufacturing unit put the company in a disastrous financial position. That whereas OSFC rejected the application of the company made under the OSFC settlement scheme floated in the year 2009 on the ground that BIFR has recommended for its winding up, it has offered to settle as per 2011 scheme, which also carries the same eligibility criteria.
Duplicated in 2013.
Mallards.
11 scheme, 9 scheme is duplicated in 2011.
2011,
yes,
with a certain Mallards calculations which just enhances the amount.
Because no, that is only lapse of period. Amount escalates because of
not interest. There was a substantial, there was a slight difference in the calculation also, which would increase the amount by substantially in the mode of calculation. And that clause was also there. Carries the same eligibility criteria. Since the eligibility criteria for both the schemes are same, the petitioner company being found eligible to settle its outstanding loans as per OTS 2011 scheme should be naturally eligible to settle its outstanding loan scheme under the OSFC settlement scheme 2007. The OSFC seized the unit in the year 1996 and all the assets of the company, including its plant, machinery, equipments and civil infrastructure remain under the physical control of the OSFC under its watch and ward. Expenses incurred for such watch and ward has been a charge on the company. The company is desirous to restart the unit and in the process it requests to conduct and undertake the joint verification of assets seized by OSFC kept under its watch and ward. The orders passed by the Honorable High Court of Orissa permitted the company to make an application for OTS, raising all contentions in a comprehensive manner, listing out all relevant facts. Consequently, we have approached OSFC several times for our statement of account, copy of prevailing OTS scheme, if any, list of assets seized, kept under the watch and ward of the OSFC and verification inspection of the same. We also gave a written representation dated 27/6/2022, seeking the information documents. However, we are yet to get the information from OSFC. Permission for verification, inspection of the seized assets, stroke unit, has not yet been given. We have made all efforts to settle the outstanding OSFC under OTS. In the process, we have approached OSFC several times and have also approached the Honorable Lok Adalat. We once again earnestly seek for information documents sought by us that as responsible.
What are those information and
these are the three things, my lords: verification, account statement, the verification and inspection of the seized assets. That was vital because, my lord, that was a considerably expensive machinery. A part of the machinery itself would be enough to cover the entire loan.
We do not want.
My lords. Now that as responsible citizens, we are once again requesting for a one-time settlement of the outstanding. We offered
we have been taught in the law school,
my lords,
on the basis of chitti on contract.
My lords,
we have been taught a proposer cannot make an unconditional, conditional offer. First principles of contract law. Cheshire, Fifu, Formston, the Mullah, Pollack, all they will say this only. Anson, they will say, an offerer cannot make the offer conditional. Then that your argument violates this. Your representation violates this because Supreme Court said, Honorable Supreme Court in 3 decisions said, OTS scheme contemplates offer and acceptance. If that is so, if you do this, I will do this. How can that be? You are a borrower. Your duty is to make the payment. Except when you are entitled to rebate, etc., like Debt Relief Act, Farmers Protection Act. You are not a farmer. You are an industrialist. You borrowed money in 1988 when money value was very high. The purchasing power of money was very high. In 1996, seizure took place. In 2011, you made the representation for waiver offer. You said that was considered under 2011 scheme. Because that was the extent scheme.
That is still the extent scheme. That is still the extent scheme.
Therefore, what is your right? How OTS, what Honorable Justice Nagaratna Madam said in that in OTS matters, writ court has no business to it.
Lordship may kindly come to the next 3-4 paragraphs. Lordship may.
I read the entire all paragraphs.
So far Lordship has travelled little more, my lords. I'm only beseeching your lordships. Amount outstanding, page 85. Amount outstanding in the in both the term and the loan accounts, including penal interest as on date of the seizure of the unit, that is 19/4/1996, as per statements issued by OSFC, amounting to rupees 35,78,925.85. And simple interest calculated at the rate of 12% per annum from 24/96 till date on this amount of 35,78,000, net of repayments made, interest thus calculated amounts to rupees 1,18,82,033. To 3, the total OTS amount offered by us, including principal and the interest, amounts to rupees 1,54,60,959. As a proof of our bona fide, we have already deposited an amount of 20 lakhs by demand drafts bearing number so and so, dated 24/3/2023, drawn on the State Bank of India.
There is nothing. You are working on the beaten track. We have already read it. Nothing.
So therefore, and the paragraph 5, we request for joint verification of the assets seized by OSFC kept under its watch and ward.
Sir,
loss arising.
We have a question. Since you have taken more time, which otherwise belonged to your colleagues. You are operating under OTS scheme. Let us read the terms of scheme.
Terms of the OTS.
Can you put condition? If you do like this, then you consider whether scheme recognizes that. It is a concession.
I fully agree, Manoj. Though I'm one with your lordship on that. On that ground, on that score, we would have no grievance.
Please tell you.
Only grievance is this, Manoj. Only grievance is this. that this is an extremely high value, my lord's, machinery.
We do not.
Which I was only asking for a joint verification, less the amount of the machinery which was under the watch and ward of OSFC and which must have depreciated. Now only that's a fair demand to make.
No.
And that's equitable also.
You are a honey seeker.
Yes.
You are a honey seeker. No right to you. Your honey seeking is under a particular instrument of OTS. Whether this argument OTS scheme accepts. Let us see the terminology of the OTS scheme. You can travel by that. Therefore, I quoted Hari Vishnu Kamath.
The OTS scheme is
sure that whether this argument it accommodates. If it does not accommodate, we will not permit you to argue all that. We are not in first appeal. This is a writ jurisdiction. It is 227.
Scheme is this. OTS scheme is annexure 5.
Yes. So, however, the scope of the scheme, intent and content, policy content of the scheme will accommodate your argument. Show that.
Well,
which is that judgment? Take out. Can anybody help us? Hari Vishnu Kamath versus election tribunal. That judgment. Is you are one of the members of the Constituent Assembly. He have made the case in Supreme Court. They have decided for the first time what is meant by assurance. Hari Vishnu Kamath versus Syed Ahmad Ishaq. 1955 ARSC. If that scheme does not accommodate the kind of the argument.
Date of judgment is 9/12/1954.
That's what.
Yeah.
Well, I'm going to that.
If the scheme does not, therefore, if the scheme does not admit, then that argument the writ court cannot entertain.
Can I, my lords, take some time to examine it?
You have argued, you have taken more time than was.
No, I'll
In 2013,
only for
it was
this
given to him.
point.
He didn't pay anything. It was cancelled. OTS was cancelled. Then again, by virtue of the order passed by this honorable court, again OTS was offered. He didn't file any application, nor responded to it. Thereafter, my lord, the impugned order was issued, requesting him to either pay the amount or participate in the auction. E-auction.
When the auction is scheduled?
Auction, my lord, 4/7 order. 5/7/2025.
5/7/25.
Yes.
Auction is over.
Yes.
Who is the buyer? Auction purchaser.
Well, auction purchaser is.
He is implemented as a
yes.
OP2, 3.
OP4.
OP4. Who are 1, 2, 3? Who are OP1, 2, 3?
1, 2, 3 are states.
SFC.
OSFC.
State. OSFC.
Fedor's electric at page 10 of my application, IA, flag F.
Auction was held on?
5/7/2025. The settlement 12 crores, 12 lakhs, 30,000.
12 crore?
12 lakhs, 30,000.
Whether he has remitted the entire money?
He has asked for his money back because they did not disclose the fact that
7 crores somewhat he has paid.
He has paid 7 crore order.
Because the order was there that not to proceed.
That was not disclosed to him, so. He has deposited, my lord, 7 crores, 89,086 lakhs.
His IA is there. I have filed an objection to that IA.
89 lakhs, 86,500.
Flag G is the IA filed by the my lords,
Including AMD amount, he has deposited this.
the auction purchaser has filed an IA that's at flag G.
Because that is due to pendants of this case, my lord, he has.
Yes, sir. Now, will anybody appears for him?
They have appeared.
I have filed an application.
They have
I filed an application because by virtue of court's order, we have proceeded, but because of the prohibitory order, we have not disclosed, my lord. Now, permission will be granted.
What is the prohibitory order?
My lord, e-auction to be held tomorrow shall proceed as per rule, but the same shall not be finalized till next date. We have filed an
They have
application.
appeared. Somebody has appeared for them. Put in an appeal.
Because of the pendants of the case, my lord, he is not willing. And he has filed an application to report.
My lord, I'm only praying, my lord. It's an argument of equity. I'm only praying for an argument of equity. Equity is my assets, only a joint verification.
In commercial transactions, equity is alien.
My lord,
Because it's a commercial. It's
my lord, as long as
seeing you.
My lord,
Or some startups
I get the
belonging to rural
point. Question is here, my lord. Here, your lordship may kindly appreciate one small subject to your lordship's, my lord. Whatever falls from your lordship, my lords. One small point, my lords, I would just like to pray for your lordship's, my lord's appreciation is this, my lord. The assets were kept under the watch and ward of the OSFC.
Yeah, you said
they are charging
you, etc., etc.
They're levying a charge on that head, which is a part included under that 54,000 and all that. That's included under the outstanding. So, am I not entitled to set off of the loss against that asset?
For that, you file a suit. We'll permit you.
Am I not entitled for a
but not in this proceeding.
No, in the process of settlement.
No, not like
if I'm ready to
it is a difficult task which the court cannot take.
That is what I'm exactly praying for.
Only what exactly we are denying. We cannot try. Otherwise, wherever you make out claim, we always we are very nobody wants to go.
I have been
joy at heart.
I have been, my lord, singularly very appreciative, my lord, your lordship.
There is something. He is an unscrupulous borrower.
My lord,
say the least. We are not using other words.
My lords, we have already cleared the bank and other things, my lords.
We do not.
My lords. So I leave it to your lordships, how your lordship will...
No, how is it quite said? We heard you for such a length of time. Well, because the figures were little high. They are like astronomical figures in your state.
Exactly,
so,
my lords.
We gave you a lot of indulgence. Where is the error apparent on the face of the record in the letter of Harish to Kamal? Where is the error? What is the error? Error is your man borrowed the money and did not pay it. That is the error. And see, you went for amicable settlement. You gave an OTS offer in 2009. They considered it in 2011. The terms of 9 and terms of 11 are duplicated. And you said there is some variation which has resulted into escalation. You are not demonstrating before us. And after having given OTS proposal, can you now wriggle out and say?
No, I'm not wriggling out. I stand by that proposal. I stand by that. That has been my statement.
You did not stand, and therefore that was in 2000.
My lord, no. From the time, my lords, I have started arguing for the lordship. That is the stand.
I want to know, sir. And he does not want to pay money. He wants to swallow money, public money.
My lords, today also.
That house, that
no, I'm not. Today also, your lordship gives me an opportunity. Today also, I will get that.
Where opportunity? 88 loan. I was not even a lawyer.
85.
That OTS.
85.
Not 88.
No. 85, 87.
No, it was disbursed in probably 87.
85 to 87.
88. Disbursed.
And the other
today also, today also I stand by it. Lordship may give me some time, I'll settle.
Nothing. Right now. Dismiss on the following grounds. Number one, it has been long settled by the Privy Council that a debtor has to find the creditor and put the money into his pockets. First off, the stand of the petitioner is in variance with this grand old principle. Number two, petitioner was given an opportunity of one-time settlement, and accordingly he had made the offer offer under the 2009 then extant semicolon. That offer was considered in 2013 under 2011
OTS 2011
which duplicated the terms of 2009 scheme. First off, that he did not pay. Thereafter,
it was cancelled on 1/1/2024.
The OTS was cancelled with effect from
1/1/2014.
1/1/2014.
Yes.
First off, he went on litigating before the court. First, next paragraph. The long and vehement submission of the senior advocate that because of new OTS scheme of 2011, the amount, the mode of calculation of the amount due having been changed, there was escalation is not demonstrated. Next one. Even otherwise, the scope of judicial review, be it under Article 227 or arguably 226 of the Constitution, is very, very restrictive. More so when court is examining the regularity of OTS proceedings in view of judgment of the apex court. Just to make it good, so next paragraph. The vehement contention of the senior advocate appearing for the petitioner that his client was agreeable to abide by all the terms of OTS settlement, provided that the valuation, nature and nature of the security property was assessed in a joint inspection,
joint verification,
and due discount is given in respect of the reduced valuation, since the plant and machinery were in the suzerainty of OSFC
to account for that.
1995. Yes. Is bit difficult to countenance. The OTS scheme of 2009 or of 2011, under which the orders accepting OTS were made, do not accommodate argument of the kind. First of all, OTS scheme contemplates an unconditional offer, which the lender may accept with condition or without, being the legal position. Lot of argument in variance with the same made here cannot be countenanced. Dismissed. One more point you have to say. We are told at the bar that the auction of the security asset took place on 5/7/2025.
Yes.
And OP number 4, having been the successful bidder, OP number 4 or 5? OP number 5 in both the petitions.
No, only in one. First petition, he was not there. Auction was not held when the first petition was
5. Having
Fedor's Electric and Engineering. Fedor's Electric and Engineering Limited
has remitted a sum of rupees 7,89,86,500.
Yes.
Rupees.
Out of 12 crore.
Out of 12 crore, 12,30,000 rupees. The bid value. First off, interfering in matters like this will discourage the intending participants in the public options of the kind, and therefore that would be affecting the public interest at large. In since the OFCs treat the public money more as a banker and less as a promoter. Which is that judgment? Nitesh Estate versus so and so. Karnataka. Nitesh Estate versus no, SBI, perhaps it is. Nitesh Estate Private Limited versus Housing. Which is that judgment? Take out that judgment. Discuss about Nitesh Estate. Dismissed. With a cost of 1 lakh each. Yes.
Wait for minutes.
Option, give it here. Yeah.
Item 31.
One.
Yeah.
Item 31, my lord, sub-item, that day I mentioned that the entire dispute has arisen because of my plight, my
31 is your WP.
Yes, my lord. 31 W, there are two WPCs, my lord. My application is second one, my lord.
WPC 25096 of 84.
Yes.
What is the first matter?
First matter, my lord, is
Mr. Mukherjee.
Yes, my petition, but he wants to address your lordship, let him do it.
Because I don't want to address, because I need to address, because my lord, this matter, the entire his case is that he wants to get the bank guarantee from the MCL. Now, why I am in
What are the foundational facts of
yes, that's what, my lord, let me place it on behalf of the second read.
No, first one is his petition.
His petition.
Here you also. Yes, Mr. Mukherjee.
Yes.
Well, it's
your date chart.
Date chart is appended to the writ petition that is given. Well, the present petitioner,
the events are given. We don't understand
the present petitioner is a company which has been formed or come into existence pursuant to a resolution plan accepted by the company, by the NCLT under the IBC. Now, one of the assets that has come into the hands of the petitioner is a bank guarantee that was parked with the Mahanadi coalfields. I am to get back, because the work has already been executed, I am to get back that money.
You are a contractor?
No, I'm a company. I'm a company which takes up various job contracts and executes them. Now, this bank guarantee...
Contractor?
Yes, my lord. So your lordship may take it that way. So, my lord, this bank guarantee was to come into my hands. Even though the work was completed, the Mahanadi coalfield did not hand back the bank guarantee to me, or they released the bank guarantee in my favor on the plea, initially on the plea, that the petitioner in the second writ petition has put forth a claim before the MCL that he is to receive an amount. And there were certain cases which were sub judice. So, my lords, the first...
They are relating to contract. What kind of job? What was your service?
My lords, I was given. I was engaging machinery, heavy machinery, for the purpose of excavating coal.
Coal.
Yes, my lords.
Okay. You worked in the coal mine.
Yes, my lord. That was the corporate debtor who was doing it.
That award of contract was made by whom?
The Mahanadi Coalfields.
What is the status? I don't know. It's a statutory body.
It's a statutory body. It's statutory. Yes, yes. Mahanadi Coalfields is a statutory.
There, my lord, Coal India is the company. Now these are the subsidiaries of Coal India.
That company.
Yes.
These are all government company under
These are
Section
government.
617 of the Companies Act.
Yes.
Yes.
Erstwhile company.
Yes, yes. Previously, my lord, it was prior to nationalization of bank case from that. My lord, from that day, 1972, this the coal nationalization came into picture and Coal India was created. After that, and these are some subsidiaries like MCL is operating in Odisha and in Chhattisgarh.
CCL is there, MCL is there.
MCL, all.
So, well, it's 8/12/2022 is the date when the resolution plan was approved by the NCLT.
No, why it went to NCLT?
Because that company, erstwhile contractor who had contracted with MCL became sick. It went before the proceedings, went before the Mahanadi Coalfields. There was a resolution process which was adhered to. A resolution plan was worked out. Certain debts were written off by the resolution professional. It was accepted by the Committee of Creditors. Ultimately, the resolution plan was accepted by the Company Law Tribunal. That being the position, I came into existence on the 8th of December 2022. That is at page 2, the second date.
8/2/2020. 8/12.
That earlier company, earlier company did not do its job.
They failed to repay the debts. The purpose for which IBC is created. In fact, it became sick. There were creditors which were after it. The company went into liquidation, not liquidation.
Short of that under IBC.
IBC. And there a resolution professional was appointed. A resolution professional proposed a plan which was accepted by the tribunal, and that is where I come in. The plan that was accepted was proposed by me. That was accepted. Now, at page 140 is the order of the National Company Law Tribunal.
That you have challenged here?
No, I have not challenged. It cannot be challenged here.
No, what is that? Why are you here?
No, I am here. Like one of the assets which came into my hands was this bank guarantee, which was parked with the Mahanadi Coalfields, with which the company which went into liquidation or was subjected to the IBC was liquidated, had entered into a contract with MCL. And it had an asset in the form of a bank guarantee. That bank guarantee came into my hands.
It's a performance guarantee.
It is a performance.
Performance. Yes,
it's a performance. It's a performance guarantee. Yes, Malaj. So, Malaj, this amount was to come to me. So, Malaj, when I went to the MCL for release of the bank guarantee, the Mahanadi Coalfields took a plea that there is a claim which has been launched in a writ court before this honorable court, and hence the money cannot be disbursed.
So it cannot be given to you.
It cannot be released in your favor. So that was a writ petition which had been filed, the first writ petition which had been filed by the petitioner in the second writ petition, wherein he made a claim before the court that I have dues of X amount against the erstwhile company which has not been paid, and this amount is required to be paid to me. Since I am to get money from MCL, MCL is holding money payable to that company, that money be released in my favor. That writ petition was dismissed by this first round. The petitioner was called upon to show what was his relationship with MCL. He could not establish that. The first writ petition was dismissed. Kindly see Annexure 2 at page 209. Kindly see page 209. This is the first writ petition which was filed by the petitioner in the second writ petition.
Order dated?
This is order dated 28/8/2023.
It only adjourns the matter.
Then
Matter will be listed only after any amendment application is sought on record.
next, the final order is at page 20210. They did not establish. They filed a second writ petition. Second writ petition.
Kindly see the first writ petition. It is dismissed for non-prosecution.
Non-prosecution because he failed to establish. That is exactly what the reason why I showed you the order at page 209. 209, there was a requirement which was the petitioner was required to fulfill. That is establish his relationship with MCL to stake a claim over the money in question. This was not satisfied by the petitioner, for which there was no appearance. In the meantime, what he did was he moved a Section 9 application before the company court and the commercial of the Section 9 of the Arbitration Conciliation Act before the commercial court. Therein, he made an application under Order 39, Rule 3 for restraining MCL from releasing the money. That application came to be rejected, against which he carried a writ petition to this Honorable Court. The judgment of this Honorable Court is at page 211.
That also affirmed the NCLT order.
No, NCLT order has been noted there. Kindly see that order, which is at page 211. Here, my lords, I also came in.
This was post-resolution. Post-resolution.
Resolution is in 22.
22.
This is all happening in
resolution refers to bank guarantee.
I'll show all that. I'll show that what is the locus.
My lord, I'll just interrupt, my lord.
I'm asking you.
Yes, my lord.
Whether NCLT order in so many words refers to bank guarantee.
My lord, what has happened in this case? My learned senior has relied on the order approving the resolution plan, but the resolution plan has not been supplied where those assets and liabilities have been dealt with. What has been done by the Honorable NCLT Chennai bench is approving that resolution plan. When there is if I do not peruse the resolution plan, my lord, I may not be able to say that if that bank guarantee has been stated to be an asset at the hand of the new.
Therefore, we really take that question.
Yes, page 158.
Resolution plan is not there, my lord.
Kindly take page 158.
You are for the
MCL. Kindly take page 158. This is part of the NCLT's order, final order, approving the resolution plan.
158.
158, para 9.2.
It is
further submitted that the resolution plan provides for protection of necessary bank guarantees by undertakings to reimburse in case of invocation of life bank guarantees after effective date per subsection 3.2.24 of Part B financial proposal of the resolution plan.
These bank guarantees are same or different bank guarantees?
I cannot say, my lord, because that's not.
You don't have that.
Yes.
There are multiple bank guarantees, and this also covers that. My lord, that is,
my lord, only see page 14. In fact, that some bank guarantees have been kept out of the ambit of that. May I just read one?
His bank guarantee appears in that.
No, I cannot say because of the absence of.
But some bank guarantees have been excluded from that. What appears from what my learned senior has stated in the report.
Answer MCL's, what is the MCL's contention? I will answer that. But let me first of all show what the petitioner in the other writ petition has done to stop me from getting my money. Now, I was taking your lordship to the order of this honorable court in that proceeding against Section 9 proceeding. The Section 9 proceeding, Order 39, Rule 3 application was filed. It was rejected. Against that, he carried a writ petition to this honorable court. This honorable court, while dealing with that writ petition, has passed an order which is at page 211. I wanted to show to your lordship. Saying, my lords, ultimately rejecting their prayer, but with some very harsh observations. Anyway, page 231, his writ petition was dismissed.
His means?
His means the petitioner in the second case. Yeah. Mr. Patnaik's plans. Yes. Now, against this judgment, he went to Supreme Court.
They are also dismissed.
232, that was also dismissed. Now, after this dismissal of the writ petition.
Who is Patnaik here? Yes. Who is he? What is his role in the
He is one of the operational creditors.
No. My lord,
let me come to who's the petitioner?
He has very, in a very good manner, he has escaped that question. Who am I?
My lords, let me complete, my lords. His endeavor is not to allow me to speak. That's why I wanted him to speak first.
Clarify.
But they can both clarify after I complete. नहीं अपन नहीं कि ठीक है रोहित कोई थी मुझे देखिए रे इंटर से इंटरवेंशन पे फाइल करा इंटरवेंशन फाइल करा तो रिजेक्ट है and come to that show everything.
But Mr. Mukherjee, kindly see section 137 or 133 of the evidence.
Yes.
Court can put any question.
Yes.
To anyone.
Yes.
Any stage of the proceeding.
Now, my lords, I am the one who is being put questions to and I am to answer. Three of us cannot answer together.
No, we asked him to answer. It's cross prerogative.
My lords, let him complete. Let him complete. I will
query. Do not get offended when judge says law. When judge reminds you the law, you should be happy. You should say thanks to the judge. Don't get offended. I am only controlling you by bringing the law to your legs. That's all.
Thereafter, after his dismissal of the SLP in the Supreme Court, he filed an application under Section 11(6) for appointment of an arbitrator before this honorable court. That is Annexure 13 at page 233.
Can you give a thumbnail sketch of who is he? We'll ask you now.
He was a subcontractor. He says he was a subcontractor against the erstwhile creditor, against the corporate debtor who went into IBC. Now, I will show from the resolution plan that his claim was put forth in the resolution plan itself and has been negatived. I will show it to your lordship. Kindly bear with me. But I just wanted to show the series of litigation that he has indulged in and where this honorable court's time and again has been called upon to address upon his claim, and each time it has been negatived. So 11(6) application gets dismissed by this honorable court.
Dismissed on?
On 16th of February 2024. Annexure 13 at page 233. Now, my lords,
was it not carried forward to the...
This was not carried forward. Now, thereafter, he pursued with the Section 9 application before the commercial court. Now, that was
39(3).
Section 9. Final Section 9. On 26th of February 2024, the Section 9 application was also dismissed by the commercial court.
Dismissed on?
Dismissed on on 26th of February 2024. 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 26th of F
The earlier one, 11-6 was dismissed on 16 to 24.
This was on 20.
Section 9 was dismissed on 26 February 2024.
Now, my lords, thereafter, he filed another writ petition before this Honorable Court on the same cause of action, saying that MCL should pay the money that is payable to me by not releasing the bank guarantee in my favor. This writ petition, no notice was issued, but this Honorable Court, at the first hearing, passed an order that his representation pending with MCL be considered. So MCL considered that representation and rejected his claim. That was on that was rejected, Annex page 35, Annexure 1 of his writ petition. Annexure 1. So he made a representation pursuant to the orders of this Honorable Court, and that representation was considered by the MCL and was rejected.
What was his prayer in that representation?
To release the amount. Release the amount from my bank, by deducting it from my bank guarantee, the amount be released in his favor. Whatever was payable to me from that amount, his dues be released. May I read out the relevant portion, my lords?
My lord, can I just get my lord conviction?
We'll come to you.
Yes, ma'am.
We'll not pass any adverse order without hearing. No, we have heard you first.
Thereafter, my lords, what is important is that resolution plan, what my learned friend was submitting to your lordship, that his claim was not part of the resolution plan. Now kindly see that, my lords. That is at page kindly come to page 117. Your lordship has that? Page 117. Your lordship has page 117. Page 117.
To furnish performance security.
No. Page 117, Annexure 5 in WPC number in my writ petition. That is the 11891 of 24.
That is statement of?
That is your lordship sees at the top, name of the corporate debtor, Sikal Logistic, date of commencement of CIRP is so-and-so, list of creditors as on 8 September 2022.
In that he does not figure.
I'll show you. He figures. List of operational creditors other than workmen and employees of government dues. Now kindly take page serial number 123. At page 125, his claim, he figures there.
No, there is no mistake in this. One page is back and forth.
Page 125, serial number 123. This is the petitioner in the second writ petition, and his claim, as put forth before this Honorable Court, is also does figure before the.
Figure is 27,600.
No. It's 123, page number 120, serial number 123 at page 125. 6 crores for 2 lakhs.
For 2 lakh.
6 crores, 2 lakhs. 6
crore, 2 lakh.
Yes.
Yeah.
It figures there.
Yeah.
Thereafter, my lords, your lordship next sees what is approved in the resolution plan, page 154. This is part of the resolution plan which was approved. Page 154. Settlement proposed to the stakeholders in the resolution plan. Now your lordship sees
the success
at page 155, operational creditors, that is serial number 3, operational creditors as on December 31, 2021.
December 31, 2021.
Yes. Now, in second entry in that list is other operational creditors related parties, which is the list I had read out to your lordships earlier, under the list of claims. So the total amount due from other operational creditors is 370 crores. And the amount which is provided under the resolution plan is nil. So this is where the operational creditors' claims get wiped out.
This is an order made by the NCLT.
NCLT. Now, my lord.
It's true.
Yes, ma'am.
NCLT has made this order.
Yes. This is the resolution plan. Now, my lords, what is the effect of the resolution plan? Section 15.
2016 or 17 judgment is there. No?
Ganesham. I'll show that to you. I'll just come to that.
Justice Nariman's.
Yes. Now, my lords, section 31 of the IBC that provides for approval of resolution plan. Anybody who is aggrieved by the approval of the resolution plan or any decisions that are made therein, their remedy is under section 61. Section 61 provides for appeals and appellate authority. Notwithstanding anything to the contrary contained in Companies Act, any person aggrieved by the order of the adjudicating authority under this part may prefer an appeal to the National Companies Law Appellate Tribunal. NCLAT. 3 is an appeal against an order approving a resolution plan under section 31 may be filed on the following grounds. That the approved resolution plan is in contravention of the provision, there has been material irregularity. The debts owed by operational creditors of the opposite party have not been provided for in the resolution plan in the manner specified by the board. So, my lords.
Like Patnaik's claims.
Yes, my lords. So, his claim, whatever his claim, operational creditors' claim was not provided for in the resolution plan. His remedy, therefore, lay in filing an appeal before the NCLAT, which he has not done. And if he does not do that, what is the effect, my lords? Once the resolution plan is accepted, the effect is what has been laid down by the Honorable Apex Court in the judgment of Ganesham. That is,
Ganesham is not, that means it's not little loosened in the subsequent judgment.
It has been approved repeatedly.
Reiterated.
Yes.
Some amendment was done by the Parliament.
My lords, the latest position of law has not changed. This is the position, and this is what has been quoted at page 175. In the resolution plan itself, they have taken note of this. In the approval order, page 175, if your lordship takes. It is asserted that by virtue of the approval...
3.115.
115 minutes. It is asserted the virtue of the approval of the resolution plan by the adjudicating authority, the resolution applicant shall take over the corporate debtor on a fresh slate. The fresh slate principle has been enunciated by the Honorable Supreme Court in the Committee of Creditors of SR Steel versus Satish Kumar Gupta and others. and further ratified and crystallized by the Honorable Apex Court in Ghanshyam Mishra and Sons.
In other words, whoever is not figuring there, his liability, these people need not take, appears to be the intent of this paragraph.
Yes.
That's all.
That's all. His claim was taken note of during the proceeding. He was identified as a operational creditor.
Other than workmen?
Other than workmen. He was one of the operational creditors that were there of the sick company. And the operation, as far as the dues payable to the operational creditors are concerned, in the resolution plan, nothing was provided.
So he cannot come and stand right in front of you on fine days. That is the content of this.
That is the, because it would be nullifying the
approved plan itself.
Absolutely. It would be reopening the entire resolution. That is not permissible in law. The language is this, my lord. All claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what has to be paid in order that it may take over and run the business of the corporate debtor. This the successful resolution applicant does on a fresh slate, as has been pointed out by us herein above. So I start on a fresh slate. Today, somebody cannot come and say that I have to receive this money from the erstwhile creditor and I will take it from you. Now, this gets approved.
So, those who are aggrieved, for them, there is a remedy which they should follow.
They have to, that is the only statute, statute provides for that remedy. He cannot come in a writ petition and do that. And that has been...
Any limitation period is prescribed there.
There's that.
Limitation is prescribed, but it's a time limit.
Any provision for condonation of...
No. That is another last thing, my lord. And that part, my lord, Honorable Supreme Court in a latest judgment, my lord, has castigated the entire thing, has stated that there has to be some kind of provision so that Limitation Act will be made applicable. The same rigorous provision is also there in the GST Act, my lord, 1074.
Why section 17 of the SURFACE?
SURFACE also, my lord. SURFACE, Arbitration Act, my lord, Arbitration Act. The outer limit is fixed. It cannot be entertainable. Now, my lord, similar case has been pending before Honorable Chief Justice also, where all these questions are being decided, my lord.
So at page 187, para 25, on hearing the submissions by the learned counsel for the resolution professional and perusing the record, we find that the resolution plan has been approved with 77.55% voting share. And we have infused, as per the COC, the plan meets the requirement of being viable and feasible for the revival of the corporate debtor. By and large, all the compliances have been done by the resolution professional and the resolution applicant for making the plan effective after approval by this bench. On perusal of the documents on record, we are also satisfied that the resolution plan is in accordance with section 30 and 31 of the IBC and also complies with regulation 38 and 39 of the IBBI. Para 28 on the next page, subject to the observations made in this order, the resolution plan in question is hereby approved by the adjudicating authority. The resolution plan shall form part of this order. The resolution plan is binding on the corporate debtor and other stakeholders involved so that the revival of the debtor company shall come into force with immediate effect. Then next paragraph, the resolution professionals submit the records collected during the commencement of the proceeding to the IBC for the record and also return the resolution applicant for or new proposals. And Ghanshyam Mishra's relevant portion is quoted at page 223. This is of Justice Nariman. May I read out that portion? as that quoted portion, my lords, in paragraph 13. As discussed herein above, one of the principal objects of the INB code is provided for revival of the corporate debtor and to make it a going concern. INB code is a complete code in itself. Upon admission of the petition under Section 7, there are various important duties and functions entrusted to the RPA and COC. RPA is required to issue a publication inviting claims from all the stakeholders. He is required to collate the said information and submit necessary details in the information memorandum. The resolution applicant submits the plan on the basis of the details provided in the information memorandum. The resolution plan undergo deep scrutiny by the resolution professional as well as the committee of creditors. In the negotiation that may be held between COC and the resolution applicant, various modifications may be made so as to ensure that while paying part of the dues of the financial creditors as well as the operational creditors and other stakeholders, the corporate debtor is revived and is made an ongoing concern. After COC approves the plan, the adjudicating authority is required to arrive at a subjective satisfaction that the plan conforms to the requirements of as are provided in subsection 2 of section 30 of the INB code. Only thereafter, the adjudicating authority can grant its approval to the plan. It is at this stage that the plan becomes binding on the corporate debtor, its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. The legislative intent behind this is to freeze all the claims so that the resolution applicant starts on a clean slate and is not flung with any surprise claims. If this is permitted, the very calculations on the basis of which the resolution applicant submits its plan would go haywire and the plan would be unworkable.
Otherwise, he would come forward at all.
Because I would not have come forward. That once a resolution plan is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtors, its employees, members, creditors, including the central government, any state government or other local authority, MCL that is, grantors and other stakeholders on the date of approval of the resolution plan by the adjudicating authorities. All such claims which are not part of the resolution plan shall stand extinguished and no person would be entitled to initiate or continue any...
stand extinguished?
Yes. Extinguished and no person will be entitled to initiate or continue any proceeding in respect of a claim which is not part of the resolution plan.
Very right. Commit suicide. Because he cannot go. Not only taking him out of the forum, but the killing his right to substantive right itself.
Absolutely. Thereafter, the next important portion is quoted from the Committee of Creditors SR Steel's case at page 225. The highlighted portion your lordship may see. All claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what has to be paid in order and that it may then take over and run the business of the corporate debtor. This the successful resolution applicant does on a fresh slate, as has been pointed out by us herein above. So, my lords, to answer my writ petition, wherein I have prayed that MCL release my bank guarantee forthwith. And the MCL there has come forward with a letter. Kindly see, my lords, the counter affidavit filed by the MCL in my writ petition.
MCL is represented by whom?
By
represents the HCL.
Now, my lords,
in the light of this law, what are the facts you want to submit to us?
Yes, because that is what I'm showing to your lordship. Your lordship sees para 30, page 6 of the counter. Para 13, your lordship firstly sees the deponent most humbly, this is MCL saying, the deponent most humbly submits the OPs have not been able to release the bank guarantee as the closure of the contract has not been done inter alia owing to the matter between the petitioner as well as Om Sai Ram Tours Transport Limited involving the OP being sub judice before various forum, including the Honorable Court, and is neither deliberate or not intentional. Om Sai Ram is the petitioner in the other writ petition. Next paragraph. The deponents further reiterate that there being an amount of 1 crore 62 lakhs odd being liable to be recovered from the contractor, which is also communicated to it, the release of the bank guarantee before the closure of contract shall be prejudicial in view of the fact that the retention money, etc., has already been released in favor of the petitioner, and except the bank guarantee, there is no other amount left with the opposite party to secure the amount, if any, which shall be liable to be recovered from the petitioner. So now MCL also puts forth a claim of 1 crore 62 lakhs. Kindly see the period of contract, period of claim, page 10 of that counter affidavit. Second paragraph, your lordship sees of that letter. After receiving the proposal from the project wide so-and-so, the approval of shortfall penalty amounting to rupees 1 crore so-and-so only of physical logistics, etc. for the period, this is important, 30/12/2018 to 31/3/2022. My resolution plan was approved in December 2022. So if at all MCL had a claim, they ought to have put it forward before the resolution professional. And if they have not done so, that claim also stands extinguished by operation of law.
Because of Ghansham only.
Ghansham. That is basically Ghansham Mishra is only an interpretation of what the IBC statute says. So, my lords, in these circumstances, I had made this prayer before your lordships in the present writ petition. Your lordship may kindly see my prayer. Which? 1/7.
Give the bank guarantee.
Yes, ma'am.
With the pending excess penalty amount.
Yes.
What is that?
An amount of 31
How
lakhs.
this is arrived at?
That is what they had named at some point.
Where they have said, who will quantify this? Where is the basis of quantification?
Your lordship may not go into this excess penalty thing because I am not very sure as to from where it has sprung up.
You give up prayer number 2.
Prayer number 2, your lordship may not.
You file a memo. You ask your record to file.
I will file a memo.
That is
prayer number 2. I'll
31 not 38 lakh 467.67. Okay.
That I will not press my lords for the time being. Now, my lords.
Paper.
Paper.
Give it up. So that at least to that extent our brain is not drained.
Now, my lords, when this matter was on the board, second writ petition was filed. And in the second writ petition, this honorable court, the coordinate bench, has been pleased to make an order, which is the last order passed by your lordship of this honorable court. You kindly lordship may see that order.
Second writ petition is of Mr. Patnaik.
Yes, Mr. Patnaik.
Let him argue and you can reply also.
No, but there is an order. I just wanted to point out that order. Kindly see order dated 11/2/2025. Para 3 is important petition. In view of the above, the court makes it clear that pendency of the writ petition.
Brother K.R. Mahapatra's, no, Sanjay Kumar Mishra's, it was also bench matter, na?
This very same matter, my lord. It was previously before that bench. Where there
is no interim order passed in the
So, my lord, the court made it clear, paragraph 3, that in view of the above, this court makes it clear that pendency of the writ petition shall not be a bar for the opposite party number 4, that is me to approach the opposite party number 2, that is Mahanadi Coalfields, to release the bank guarantee, and in that event, a decision in that regard shall be taken by the opposite party number 2. Now, if your lordship sees today's cause list noting in the cause list is there, my lords, your lordships will find that it is recorded. Order number 2 dated so and so may kindly be seen appraising this court about the decision taken on the application to be filed by opposite party number 4 is there for reference. So, but fact remains that till today, amount has not been released. The bank guarantee has not been released here. And we are going on paying money for keeping the bank guarantee alive.
It's a time-bound bank guarantee.
Because bank guarantees are usually time-bound. It's for 6 months or 1 year. And for every period that we renew the bank guarantee,
you have to make payment.
We have to pay a charge to the bank.
Renewal charges.
Renewal charges, which are pretty high because the amount is 6 crores.
So this order said you can process the claim of Mr. Mukherjee notwithstanding pendency of Mr. Patnaik's writ petition.
Yes.
What did you do?
My lord, in the meantime, we have
For 2 minutes. I'll be back.
In the meantime, after receipt of that direction from this honorable court, we have, in fact, he approached us. We have disposed of his representation, saying that now we are not weighing the pendency of the writ application and all, but there is a recoverable amount for which and closure of contract. My lord, for release of the bank guarantee, what I am required to do is, my lord, the closure of contract has to be done because it was given pursuant to a contract.
It's a performance guarantee.
Performance guarantee. Unless that
performance happens.
My lord, performance happens, I cannot release the bank guarantee. Now, my lord, I ask a question to myself that
now, in other words, you are postponing consideration of the claim, not on the ground of pendency of this his petition, but on the ground that the contract itself is not yet performed.
Partially performed, there are recoverable amount. He has only executed 22% of the work.
His predecessor.
His predecessor. Now, my lord, even this factum has been communicated to him.
Predecessor is not there. He is Sikal, my lord. The company has not changed. Company has not been liquidated. Somebody, new entity has come in and take over that company. Company remains the same. So the identity of company has not been lost.
My lord, one more thing may I apprise your lordship, that, my lord, in the resolution plan itself, what has been quoted by the other side, your lordship may see at page 13 and 14. There is a exclusion made in respect of some bank guarantees.
But we asked whether this is
that's not there.
You are not in a position to answer.
Because they have not supplied a copy of the resolution plan, which I cannot get otherwise, because that resolution plan is in their favor. They had submitted, being the successful resolution applicant before the NCLT, Chennai, they had submitted a plan, and I do not have access to that plan. So, my lord, that plan, unless that plan is supplied to me, I will not be able to see if this bank guarantee forms a part of that.
Those bank guarantees, whether they comprise this bank guarantee.
Yes, my lord, because the language, if your lordship permits, I can read where there is some exclusion.
On your ground of rejecting their application for release of the bank guarantee.
No, I have not rejected. I have said.
You have said you will consider it after the recoveries are done
and closure of contract. First is closure of contract. Unless the closure of contract is done, I cannot release the bank guarantee.
About that, NCLT has not said or said it is not known to you.
No, not known to me. And apparently, this bank guarantee, the Honorable NCLT also has directed that it should be extended. So, my lord, there is a contingent liability. My submission would be this bank guarantee may not be an asset for the.
It is not an asset at all, is your contention.
Yes, my lord. Because how can that be an asset when there is a contingent liability, my lord? Because if it is invoked, say, my lord, now if MCL chooses to invoke the bank guarantee, it's an independent contract. Now bank will release the amount.
if I invoke the
So
bank
he has nothing to do with that, your contention.
No, he definitely has a point, legally speaking, because ultimately it has to be settled, recovered from the corporate debtor. My lord, I cannot say something which is not legally. I mean, it comes to my mind that say, suppose today MCL chooses to invoke the bank guarantee.
No, if the bank guarantee is a performance guarantee.
Correct.
So guarantee becomes invocable if performance is at stake.
Yes, madam.
Or anything to be recovered, anything to be accomplished, etc. As a guarantee, you are
yes, madam.
On the happening of that event, the guarantee becomes either revocable or invocable.
Yes, madam.
Therefore, what you say is it is not an asset at all.
Yes.
If the event does not happen.
It has happened. In this case, it has happened.
It has happened.
Yes, my lord, because 22% is the work completed. And extension was sought for within the time the erstwhile corporate debtor was under CIRP. Even then, extension has been taken and it has been granted by MCL.
Whether the NCLT proceeded on the assumption that work has already been accomplished? No, it has not.
I don't find anything.
Mr. Mukherjee, why can't you give that resolution plan? Because to answer that question, you should know what is the resolution.
Yes. Well, it's a solution. It was open for him. If he had any claim, I've already shown to your lordship what was the contract period.
No, not he.
No, I'm talking about MCL. I have shown to your lordship from their annex share what was the contract period.
No, why can't you give a copy of the resolution to him? So that he will be able to
my lord,
answer.
one more thing is, my lord, it was the date on which the resolution plan has been approved. Your lordship may see it intermingles with the date of completion of the contract. So, my lord, unless
the dates are fixed.
Yes.
On the basis of the contract.
Yes, my lord. So, unless the period is over.
Period was over.
How do I make a claim, my lord? And what I presume, my lord, because it has been given that you have to extend the bank guarantee, so a contingent liability was already in the mind of the Honorable Tribunal, my lord. So that I have to check.
What
yes,
they have said in the resolution will be.
Yes, that's exactly why I was, my lord,
Mukherjee, what your friend says appears to be sensible. It is a performance guarantee.
Yes, Maharaj.
According to him, he says only 22% of the obligation is discharged under the contract. 78 remains yet to be. So, unless that is performed within the cutoff date, which is reflected in the order, you are not entitled to take the return of the bank guarantee.
I have twofold answer to this. One is, if at all, the contract period I have shown to your lordship.
Correct.
The contract period was from 30/12/2018 to 31/3/2022.
Correct.
The resolution plan was approved much later. It was in December 22 that the resolution plan was approved. List of claims of the creditors that was put forth before the resolution plan there is no claim of the claim is up to the date 8th September 2022. That is at page 117.
What was your proposal to the NCLT in your resolution?
Yes. My proposal.
Resolution should be known. Yes, the resolution professional.
Yes.
Unless that item is also contemplated by the NCLT, we are not in a position.
No, whoever has any claim, because I am a new entity, I don't know what are the liabilities of the.
No, my lord, that submission I'll only submit before your lordship. My lord, there is a resolution plan submission date and there is a claims last date for submission of claims. So it precedes that date. Before this resolution plan came to be submitted or approved, much before that the claim submission date has ended. So, my lord,
if by that, the last date of submission of claim date, if my tender was not over, I did not have an opportunity to
Put forth also.
Yes, my lord.
Same, my lord.
So, my lord, in any case, my humble submission would be the other side, the petitioner
You,
maybe.
you furnish the resolution.
My lords, I'll come to that, but before that, it is not open for the Mahanadi Coalfields to ask for the resolution plan now. Why? Because kindly see, the contract ended on 31/3/2022. Kindly now come.
Contract period came to an end.
Yes, on 31/3.
Obligation is discharged or not is the question.
My lords, I am coming to that, my lords. It ended, my lords. So on the date of the end of the contract, if there was any liability or no liability was known to MCL.
No, what he says is that
I did not do the work. And he had claim. He had claim on me. Let us assume of a situation that he had a claim on me. Now kindly come to page 117.
Lord, that is the list of claims, my lord. That claim submission date is preceding the date of completion of the contract, my lord. I cannot submit a claim before it has materialized.
My lord, your lordship has page 117.
Yes, sir.
Kindly see. Commencement of CIRP is 10th March 2021. List of creditors as on 8th September 2022. That is after 31/3/2022.
List of operational creditors.
Yes, if at all they are creditors, they are operational creditors only, nothing else.
What is meant by operational creditors?
Yes, my lords. Let me place.
The definition is there.
Yes,
Section 9.
it is there.
Section 9.
Do you fit into that?
My lord, my humble submission would be subject to my learned senior's approval, my lord. I'm just requesting, my lord, a copy of the resolution plan.
Sir, that also you need that.
Yes, my lord, because on the last date, I had asked my learned seniors associate to supply a copy of the resolution plan in the court itself when this matter was going on. I presume he might have missed his mind. So, my lord, what I submit, my lord, a resolution, supplying a copy of the resolution plan. If he wants, I can get it printed. He can supply a soft copy of the same. That's not a problem, my lord. I just need to verify.
How many pages?
It's a PSU, my lord. It must be running into hundreds of pages, my lord. As far as I know, my lord, our resolution plan will contain everything. All dates, all claims, everything would have been dealt with.
Complete code.
Yes, yes. It has been supplied by the client of my learned senior because he is the successful resolution applicant.
Operational creditor.
That is here, my lord. Section 220, my lord.
Means the person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Operational means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So, my lords, assuming that the corporate
assignee,
yes, the corporate debtor had entered into a contract with MCL. So, if at all MCL had a claim over the creditor, it was an operational debt, and he would be an operational creditor. So, if he had any claim, it was his obligation on when the resolution plan was under consideration to put forth that claim before the resolution professional.
It will be before the cutoff date of.
My lords, the cutoff date I've shown to your lordship, the cutoff date is definitely after September 2022.
Just read one paragraph from the resolution plan which supports my contention, my lord. He has quoted that.
the respective financial creditors that have issued the bank guarantees that are listed in Annexure 5 of the resolution plan, necessary bank guarantees, shall continue such necessary bank guarantee and renew such necessary bank guarantees till such time as may be required by the corporate debtor from time to time, including after the effective date. And including such time that the bank guarantee, if being replaced,
it can transcend the cutoff date.
Yes, my lord, that's provided in the resolution plan itself. So, my lord, unless that resolution plan is there, I may not be able to say that because.
My lord, the answer to that is paragraph page 224.
No, we hear you. Kindly give a copy of that.
Lord, he has not put forth his claim before the resolution
to
plan.
answer this, whether he could have put forth is his intention.
He was obliged, kindly come to page. That is answered, my lord. That is answered in Ghanshyam Mishra.
We have to obtain this resolution, whether the
No, my lord, that resolution plan is not available on the website because it's not an order.
It's not an order.
It's a submission by the
resolution professional.
Applicant. He is the applicant. He is the successful resolution applicant. Pursuant to the plan submitted by him being selected as the approved the correct resolution plan.
My lord, the character of the company never dies. So company survives, my lord. Only an entity comes with a resolution plan, and that is accepted. So the
now,
company,
my lord, but I should concede that what my learned senior is submitting, that it's a clean slate and my lord, it will extinguish. That I cannot, because it's a legal submission and it's the correct position of law. I cannot. Yes, but I cannot verify if my claim has been extinguished or not until I have
copy of that
resolution plan. So, my lord, what I am saying, to assist this honorable court better, my learned senior associate may be directed that a copy of the resolution plan will be supplied to me so that I can verify and assist your lords.
My lord, that will not be necessary. Kindly take page 224.
What we do not understand is, there are legal arguments that can be canvassed is one thing. If you give copy of the resolution, parties will be happy. They will be knowing what is what. We also will be knowing.
My lords, will your lordship accept for a moment that MCL, which is a huge public sector undertaking, is not aware of what the resolution plan is?
No, my lord. No, my lord, it's my submission.
Can it be conceived of?
No.
Can it be conceived of?
Plan not available in the public domain, my lord.
It's not available because it is only a proposal.
Yes, my lord.
May I just read out one paragraph from Ghanshyam Mishra, my lord, which has been quoted?
That's operation of law, my lord. But unless I know if it applies to the facts.
We cannot go above the law.
No, but if it applies to the facts or not, my lord, has to be, my lord.
Question B. Whether that law is attracted or not.
Yes.
The foundational facts have to be ascertained.
The foundational facts are this, my lord. The foundation
is properly, my lord. The foundational facts, I will place it. That what is the case actually from where it has emanated, my lord.
Mr. Mukherjee, furnish a copy of the resolution. It requires due consideration. We can't haste in matters like this. Because we may lay a very wrong law.
My lord, is the court considering of reopening the resolution process?
No, we are not reopening. The court wants to have all inputs. And the resolution is one of the inputs.
And my lords, let us assume of a situation. Let us accept that situation that their claims were not there. Let us assume. I have shown to your lordship that as far as SIOM is concerned, it was part of the resolution plan. And it has been wiped out.
Yeah, no, that is not my submission. That he cannot.
My lord, if that be the submission, my lord, now if this writ application, in spite of him giving up the prayer under B, the prayer A is a money claim. It's a refund of money, my lord. If that be the submission on technicalities, my lord, now this writ application is for refund of bank guarantee, is a refund of money claim. It's a refund of money. Can that writ application, if it will be maintainable, my lord, because before this one?
Cannot have the sides of the both sides of the same coin, man. On one point, he says that you don't have a claim, but I have a claim.
I don't have.
So, my lord, this is very, my lord, who am I, my lord? What is my relationship with my lord? That has to, I will showcase my lord.
We have
entire thing.
entire copy with given.
I'll do that. But your lordship may kindly take note of certain submissions or facts, my lords. Kindly take note first, and then thereafter, your lordship may pass an order to directing me to file the resolution plan.
No, we have understood what you are saying. You are stressing what Justice Nariman said in that judgment.
What the law says, my lords, not Justice Nariman. I am not concerned about Justice Nariman, what Nariman says.
Only we mentioned the.
How the law has been interpreted, that I am putting forth before your lordship.
Correct. That is even to decide whether the law as interpreted is attracted to a fact matrix or not.
Yes,
Court can ask the parties to furnish particular documents.
And the fact matrix is what I am putting forth before your lordship, is the contract ended in March 2021
and
2022.
We are also, it is open to us to say, all these disputed facts, we cannot decide it's in the nature of money claims.
Yes, my lord, that is your lordship's prerogative. That is your lordship's prerogative, I know that, my lord.
We don't want to go to that level. If things can be ascertained by just, suppose if you say why, we do not understand why you want to hold it.
I don't want to expect, my lords, I have already faced 4 litigations just in this honorable court contesting and each occasions. And on each occasion, the person who is standing as an obstacle to my claim has been thrown out of this honorable court. Has been thrown out.
Claim. He is making a claim.
And 4 occasions. This is the 5th time he has come.
No,
and my lord,
of this matter at our hands. Taking up all your contentions, we will treat all contentions.
Yes, my lord.
Give one copy. You give it, and tomorrow we are calling it.
Yes, my lord. Tomorrow I'll have it.
Tomorrow.
Yes, my lord.
If the resolution plan is a voluminous document, my lord, I have to.
Next week you do.
Yes, my lord. The week's time, my lord, your lordship may allow.
Before we forget whatever point is.
Yes, my lord. But I don't stand in the way, my lord, but reasonable time.
And before Mr. Mukherjee smiles and leaves the court hall.
My lord, can I make my submission or I'll make that submission?
No, that first resolution.
Because my lord, my claim.
Figure here, but anyway, we will hear you.
Because my claim is, my lord, is a little bit different. He says that
is different.
Yes, my lord.
You cannot maintain that at all.
No. I can maintain.
How?
Yes, my lord. My
lord, in fact, to assist your lordship, he is not a subcontractor under MCL.
My lord,
there is a clause that he has to seek permission to sublet it to somebody. No such permission has been given by yet, so he is anyway out.
Yes,
unless
let me raise my case.
Yes, my lord.
There is no income jury.
Yes, my lord. So he may not have a claim at all.
My lord, whether I will have a claim or not, my lord may hear me first.
We'll hear you.
Yes, my lord.
Without hearing, you will not pass any orders.
Let him argue today itself.
Today we have many other.
You cannot dictate terms to the court. Now,
yes, Mr. Mukherjee are his feet there. Are you going abroad or what?
Going out of your lordship's court is going abroad. My lord, your lordship fixes it. Fix it. I'll have the copy served tomorrow. Your lordship may fix it.
Let a week's time.
On 11, how many cases are pushed in? 2 men. You will have this also. Okay. And remember that whenever how many matters are posted out? Because some meaningful things have happened.
At 2
My lord may remember one thing. Though I am a subcontractor, I have worked and they have never objected to that. Now, all these objections, it was known, they received the copy. Under an agreement. Under an agreement, I have worked, my lord, and they never objected. All these are post-objection.
No, not that.
I don't know if you have worked on.
Yes, I have shown that copy. They have received that copy, my lord. That
no, it's not
and all those bills has to come to my account. Yes, my lord. Yes.
There is a clause in the contract document.
That's what, my lord. Yes, my lord.
That clause says, unless permission is obtained.
My lord.
If you go on doing so, it will be a case of quasi-contract.
No, my lord, it's a contract by silence. It's a contract by silence. If I have performed my job, and both of them have never objected to that.
That is
I'll cite those judgment, my lord. Only thing.
Only provided permission is granted by.
No, my lord, permission, they never objected. Rather, Sikol ask them that whatever bill amount is there, you please deposit it in his account. I'll show those later.
You copy, sir, the.
One copy to me, ma'am.
To both of them, so that again it need not be urgent. You file your memo.
Yes, sir. I'll file on affidavit. Since your lordship is adjourning it.
No, memo, now I will ask you to file the affidavit.
Let the also.
We will make an observation.
Your lordship.
Because you have made the submission.
I have made the submission, your lordship may observe that, and affidavit will be filed.
Learned Senior Advocate Mr. Mukherjee appearance of the petitioner on instructions of advocate on record, Mr. So and so repeatedly said on being asked that he would give up prayer number 2 in WP number so and so, which relates to
11891 of 24.
Which relates to a claim for rupees 31,38,467.67. First, the said prayer is reproduced as below. First, he also tells, next paragraph, that his client would be filing an affidavit abandoning this particular prayer once for all. Okay.
Your lordship also record that the resolution plan as observed as filed by the court will be filed. Your lordship, as per your lordship's direction.
So supply a copy of resolution plan in its entirety. OP number 2. Signed to the petitioner in WP number
W5096.
Yes.
To make a mention, item 39 we have filed at IA. That IA will be for orders filed day after tomorrow.
What is the urgency?
Well, urgency is that they are going to fill up the post which we are to get as per the order of the Honorable Cat. That is the urgency.
What happens? It will be list pendant. So
list pendant.
I may be pardoned to mention, item number 36 may not be called tomorrow.